183,558 shillings be approved as a total current expenditure under the supplementary expenditure number 5 for financial year 2025-2026. Those in favor say and the contrary nay. The ayes have it.
Total development expenditure under supplementary expenditure schedule number 5 for the financial year 2025-2026.
Can I have order? Can I have order? Honorable members, I propose a question that the total sum of Uganda shillings 210 billion 614 million 540,809 shillings be approved as a total development expenditure and a supplementary expenditure schedule number 5 for financial year 2025-2026. Those in favor say and the contrary nay. The ayes have it. Honorable members, I now put a question that a total sum of Uganda shillings 210 billion 614 million 540,809 shillings be approved as a total development expenditure under the supplementary expenditure budget schedule number 5 for financial year 2025-2026. Those in favor say and the contrary nay. The ayes have it.
Grand total supplementary expenditure under supplementary expenditure schedule number 5 for the financial year 2025-2026.
Honorable members, I am going to miss some of you so much in the 12th Parliament. You're such amazing guys, eh? Honorable members, I propose a question that a grand total sum of Uganda shillings 1,105 billion 162 million 724,367 shillings be approved as a grand total under supplementary expenditure schedule number 5 for 2025-2026 under the various votes that were deliberated or mentioned by the Minister of Finance and under the votes that are in the schedule. Those in favor say and the contrary nay. The ayes have it. Honorable members, I now put a question that a grand total sum of Uganda shillings 1,105 billion 162 million 724,367 shillings be approved as a grand total supplementary expenditure and a supplementary expenditure schedule for number 5 for financial year 2025-2026 for the various votes that are in the schedule. Those in favor say and the contrary nay. The ayes have it.
Motion for the House to resume.
Honorable Minister.
Right Honorable Chair, I beg to move a motion for the House to resume and the Committee of Supply reports thereto.
I put a question that the House resumes and the Committee of Supply reports there. 2 those in favor say and the contrary nay. The ayes have it. Stand up. Please sit. Please sit.
Report of the Committee of Supply.
Honorable Minister.
Madam Speaker and honorable colleagues, I beg to report that the Committee of Supply has considered the supplementary schedule number 5 for financial year 2025-2026 amounting to Uganda shillings 1,762,724,367 shillings and passed it without amendments.
Motion for adoption of the report of the Committee of Supply.
Honorable Minister.
Right Honorable Speaker, I beg to move a motion that the report from the Committee of Supply for schedule number 5 of financial year 2025-2026 be adopted.
I put a question that the report of the Committee of Supply be adopted by this House. Those in favor say and the contrary nay. The ayes have it. Honorable member, thank you. I will instruct the clerk to capture the details and supply it to finance. Next item.
Item 12 on the order paper. Bill second reading. The Protection of Sovereignty Bill 2026.
You tell us. You tell me to come. Wait.
Thank you, Right Honorable Speaker.
Honorable members, you recall that on Wednesday 15th, 2026, the Minister of Internal Affairs tabled the Protection of Sovereignty Bill 2026 for the first reading. Pursuant to Rule 135 of the Rules of Procedure of Parliament, the bill was referred to a joint committee of Defense and Internal Affairs and Legal and Parliamentary Affairs. The committee has concluded the consideration of the bill and is ready to report. And pursuant to Rule 136(1) of the Rules of Procedure, I will invite the Minister to move his motion for the second reading before I will give you to bring your issue. Please. Honorable, let him first move, then I will give you to bring your issue. Okay?
Thank you, Madam Speaker. Madam Speaker, the bill you have invited this House to consider is a government bill. I saw a tweet by the head of government and a letter signed by retired General Yoweri Kaguta Museveni Tibuhaburwa.
Sabalwanyi.
That's not part of the names. So, in his letter, Right Honorable Speaker, he actually disowned.
Lob, is it in his letter?
Yes.
Can I
Let
have
me
a copy?
submit, Right Honorable.
No, I want us to talk with evidence. Can we lay the letter on table?
I came prepared, Madam Speaker. Here is a copy of the letter. I am tabling it.
I have never seen a letter from State House in white.
Madam Speaker, this is a copy of the letter, and I am tabling it. Normally we table documents, then they can be processed and authenticated and so on. But let me raise the point I was raising, Madam Speaker. In this letter, he disowned the bill that was tabled by the Minister of State for Internal Affairs. In fact, he was appalled, wondering what it is that we were debating. Also, what bothered me, Madam Speaker, in his letter he said he called the two chairpersons of committees regarding this bill. I don't know how procedurally that gets to be correct, that now the executive gets to meddle directly, because it should be you, Madam Speaker, to call chairpersons of committees, guide them and so on. But if they are getting guidance from the executive, it's a problematic issue. Madam Speaker, the Attorney General and the Minister of State for Internal Affairs went back to the Joint Committee and they made amendments to majority of the clauses in the bill. Please note, for those who have been following, amendments to majority of the clauses in the bill. For all intents and purposes, Madam Speaker and colleagues, this was now a new bill. For all intents and purposes. And by the way, there is precedents that have been set by this House, even in the previous Parliament, where...
Honourable members, I want you to listen to Lob. Lob is saying after...
Let me actually say what I am saying. I'm glad you are protecting me from some noisy colleagues.
This becomes a new bill. What I would only ask, did the new bill change the objective of the old bill? You continue.
Madam Speaker, and I'm glad you're asking that question, because the entire foundation of the bill was torn apart, and no wonder the initiator...
There's a procedure.
But I rose procedurally, Madam Speaker.
No, I gave
procedure cannot counter procedure.
No, I gave you space to speak.
But I raised...
Is yes an order?
An order cannot... Honorable, you've been around for some time. You know that procedure takes precedence. You're going to mislead the new MPs who are coming in the 12th Parliament. They need to know and learn from people. Let me proceed in earnest, Madam Speaker.
But Honorable Lob, I want to put this on record that we do not have a new bill. We only have one bill. I am the custodian of the law in Parliament. If the President wanted to make a change in that, in the law, in the bill, the President ought to have informed me. I am not aware of that. It has not come to my attention. I am the one processing the bills here. So if he sent it for public, and if he called the chairpersons, he's one of the Ugandans whom we should consult.
Madam Speaker, I'm glad you're saying you were not informed, and that's part of the problem I'm raising. Why was this House not informed? Especially because majority of the clauses were amended. Madam Speaker, please protect me from noisy colleagues. You always tell us that this is not a market.
Colleagues, please let Honorable Lob finish. Let Honorable Lob finish his submission. No. Honorable members, let's be calm. I am the custodian of the law here. I don't have a new law. I don't have a new bill. So after Honorable has finished, I will ask the minister to move his bill. You finish.
Thank you. So as I was saying, this is me saying, and you will rule and guide. For all intents and purposes, as far as I am concerned, this then became a new bill because majority of the clauses in the bill were changed. And there is precedents where ministers have been told, no, those so many amendments, just withdraw the bill and reintroduce it perhaps. What the Minister for Internal Affairs and Attorney General should have done was to withdraw this bill.
Honorable Love,
But Madam Speaker, you're not even allowing me to submit.
Honorable
Let me
Love,
submit. You're the one going to rule.
please, Honorable Love, my brother. Honorable Love. Honorable Love. Honorable Love. Can I have order? Can I have order? We have now started debating in anticipation. We don't know what the bill is. When the minister moves his bill, that's when we can reject. Huh? Please make my work easy. No, you leave Honorable Lob to finish. Switch on.
Madam Speaker, actually I am seeking to make your work easier. Really, if you capture what it is that I'm saying, because they are moving it for the second time. And for me, what I was saying is you should have been moving to withdraw the bill. That's my opinion. And you're going to give your ruling, Madam Speaker. So no, but they called for reading of the bill for second and third reading.
Okay.
So let me finish the issue that for me I am raising.
Okay.
Madam Speaker, also,
What
stakeholders...
What is the procedure matter that you are raising now?
So, the procedural matter I'm raising is, should the Minister of Internal Affairs be withdrawing his bill, and then he goes back for consultation.
Can I answer
Finally.
that first? Can I answer that first? Maybe it will form your second question. That the Minister of Internal Affairs should be moving his motion for the second reading. Because as far as I know, I have not been given another motion. I only have one motion. So you will move your second motion for the second reading.
Thank you, Madam Speaker, and I'm glad on record you have said you were not notified of a second one. That's something we are going to interrogate because, like I'm saying, as far as some of us are concerned, it's a second one. Right Honorable Speaker, the committee report to this bill here leaked and it is in the public domain. It was first shared on our parliament platforms, media houses have shared it, it is all over. Honorable Speaker, on 18th of January 2023, you were seated in the chair you're seated in, and I was standing on this very microphone. I was chairperson of COSASE. I rose to present a committee report for COSASE on Uganda Airlines. And you said, Right Honorable Speaker, I want to quote you verbatim what was on the Hansard. You said, there was a leakage of the Uganda Airlines report. A property of this parliament cannot leak, and we continue debating on it. Those were your exact words captured on the Hansard. Honorable Speaker, this report has leaked. So, given that precedent which you said, are we going to go ahead and debate this leaked report?
Thank you.
Because the precedent was set by yourself. We hope to be ready.
First of all, honorable members, in the VIP gallery, I want to introduce Honorable Namlondo Sara, MP-elect from Buyende. You're most welcome. Honorable Naku Fiona, the elect for workers. Most welcome, Fiona Naku. And then we have Honorable Sewagude Robert, representing people with disability, national. You're also most welcome. I have Honorable Matembe, Miriam, and Honorable Emily Otekat. Honorable members, I want to refer you to Rule 14. The report of the Committee on Bills shall, and I'm saying shall, be uploaded on the Parliamentary Information System for the information of members before the report is laid on table. That is 214.14a. This report that was uploaded had my signature. I even said, please place it on the order paper with my very able signature. The report of airlines that got out did not have my signature. I am the only one who can sanction a document to be uploaded, which I did, so the report was not leaked out. Can you move your motion?
Right Honorable Speaker and honorable members, in keeping with Rule 130 of the Rules of Procedure of this Parliament, I beg to move that the bill entitled the Protection of Sovereignty Bill 2026 be read the second time.
Seconded by the Vice President of Republic of Uganda, Honorable Jessica Alupo, retired. Honorable Prime Minister, Honorable Nabanja Robina, Honorable Second Hajat, third Government Chief Whip, Minister of Defense, Minister of the Security, Minister of ICT, Minister of Finance, Minister of Works, Minister of Sports, and the Hollow House on this side. And part of that house, part of the other side, including Chemongesi, Rogomayo. Thank you. Would you want to speak to your motion?
Right Honorable Speaker and honorable members,
Can I first have a justification before you bring the procedure?
Right Honorable Speaker and honorable members, the object of this bill is that the country faces a number of challenges which threaten our ability to self-govern in the absence of a sovereignty-specific law which this law seeks to address. And these include preventing undue external influence, regulating foreign funding, safeguarding national security, filling legal gaps, and managing digital misinformation. I beg to move, Right Honorable Speaker.
Thank you. Honorable members, I want to provide some guidance in this. Honorable members, the chairpersons of the committees have prepared the report, and I wish to guide as follows. From the time the bill was tabled for the first reading, there has been a very remarkable public interest in it. A review of the committee report reveals that more than 60% witnesses were accorded opportunity to present their views on the bill, including persons and institutions. These answers and questions on whether there was sufficient public consultation or not, I commend the committee for upholding our cardinal principle of public participation. 2, there was a considerable debate on the content of the bill, notably the definition of the word foreigner, the scope of application of this bill, the regulatory prudence envisaged in administration and functions, the proposed penalties, the criminal offenses, regulations of foreign policies, registration of agents of foreigners, declaration of foreign funding, and ministerial powers, among others. I have reviewed the report. The committee has established that the contentious matters have been exhaustively handled and addressed as per the public interest. The definition of a foreigner, for instance, was initially brought in a way that was not appealing to the people, but the committee has handled. Now I want members, there is no procedure, I'm giving you guidance. I know I'm touching on your minorities. Honorable members, I am giving 30 minutes for the major report to be presented, and I am saying 30 minutes. Where is the chair? And I will also give, I am aware that is a minority report. It doesn't matter whether minorities or minority. I am also giving the minority or minorities 30 minutes. If you have 10 minorities, you'll divide 30 minutes by 10 and you'll have 3. Honorable Chair, unanswered, I want timing. Let him read his report. Then you will bring process. I don't want you to waste his time. Tebandeke, I know you want to exercise your law that you're learning now. You first wait. First wait. First wait. First wait. I have given you 30 minutes.
Thank you. Right Honorable Speaker. Right Honorable Speaker, for the record, my name is Wilson Kajrenje, Member of Parliament, Nyabusho's constituency, and Chairperson of Defense and Internal Affairs Committee. I'll be assisted by my colleague, the Honorable Baka Stephen Mugabi, Chairperson, Legal and Parliamentary Affairs. May I take the honor to lay on the table the minutes of the committee, the joint committees, while processing and considering this report.
Thank
Right
you.
Honorable Speaker, indeed, I'll take the 30 minutes. Right Honorable Speaker, on Wednesday, 15th April 2026, the Protection of Sovereignty Bill 2026 was read for the first time under Rule 135(1) of the Rules of Procedure of Parliament. You referred to the joint committee made up of Committees of Defense and Internal Affairs and the Committee on Legal and Parliamentary Affairs for scrutiny, and we are now reporting under the same rule of procedure. Right Honorable Speaker, the joint committee here referred to as the committee has examined the bill, taking into account submissions from stakeholders and now presents this report. This report sets the committee's analysis of the bill's objectives, the key provisions, likely effects, together with the synthesis of stakeholder views and the committee's recommendations to Parliament. The object of the bill. The object of the bill is to enact a law that seeks to provide for the protection of the sovereignty of the people of Uganda. 2, to designate the department responsible for peace and security and the responsible entity for the registration and regulation of agents of foreigners. 3, to provide for the protection of the sovereignty of Uganda and provide for the registration of agents of foreigners, and to regulate the funding and any other assistance to agents of foreigners and for the related matters. Defects in the existing law. The bill identifies principal defect in the existing legal framework as the absence of a specific law operationalizing the protection of Uganda's sovereignty, which has allowed continued external interference in the government policies and programs. In particular, it points out the increasing influence of foreign actors and their agents in shaping policy and development priorities, often through conditional grant, conditional funding, and parallel programs that conflict with national objectives. It further highlights inadequate regulation of civil society organizations, especially those receiving foreign funding, leading to concerns about transparency and alignment with the national objectives. Additionally, the bill notes the growing use of digital platforms by foreign actors to spread misinformation and incite social discord, collectively undermining Uganda's ability to self-govern independently and safeguard its political, economic, and social stability. Right Honorable Speaker, what method did we use? Methodology. In considering the Protection of Sovereignty Bill 2026, the committee undertook an extensive and transparent stakeholder engagement process to ensure broad participation. Public notices were published in the dailies, Vision and Monitor, on 17th April. We invited memoranda and views from all interested parties. This was to facilitate meaningful input. The committee suspended the sittings for 1 week to allow stakeholders adequate time to prepare and submit written memoranda. Upon resumption on 24th of April, Right Honorable Speaker and Honorable colleagues, stakeholders who had expressed interest were accorded opportunity to present their views. The committee engaged them directly, seeking clarifications where necessary. In total, and this is unprecedented, Right Honorable Speaker and Honorable colleagues, in total, the committee interfaced with 224 stakeholders, clustered under 60 groups drawn from diverse sectors. In the diaspora, the Global Forum Uganda Diaspora Council, whose memoranda included views of Ugandans drawn from 32 countries across all regions that gave their perspectives on the bill. In addition to the hearing from stakeholders who appeared before the committee also took into account the perspectives shared by His Excellency the President in his guidance to the nation through his letter, particularly that was addressed to the Bazuku regarding the bill. Following these engagements, Right Honorable Speaker, the committee held further sittings during which the learned Attorney General responded to the stakeholder concerns and proposed refinements to the bill. The interactive process ensured that the review incorporated both legal scrutiny and practical implementation considerations. This structured approach, characterized by open invitations, dedicated submission time, inclusive hearings, responsible dialogue, demonstrates that the committee's work was informed by a wide participatory and national representative consultation process. The stakeholders the committee interfaced with include the following. It is important, Right Honorable Speaker, that this goes on record. We have clustered them like this. We had stakeholders under government and public institutions. These are actors with statutory mandates that include Bank of Uganda, Financial Intelligence Authority, National Planning Authority, Uganda Human Rights Commission, the parliamentary committees. We also had another cluster of legal and professional bodies and organizations that focused on the law, like Uganda Law Society, like East African Law Society, the Law Development Center, Center for Constitutional Governance, that had in their entourage former members and former ministers of government. Independent legal and legal practitioners who forwarded multiple submissions. We had political actors and movements, political parties, or politically affiliated formations. These include Alliance for National Transformation, Forum for Democratic Change, National Unity Platform, the People's Front for Freedom, and for the record, the Hansard must capture this, Right Honorable Speaker, that Uganda People's Congress appeared and gave their views, and that the leader of opposition also appeared and gave his views. I'm mentioning it for the capture of the Hansard. We also entertained private sector and business associations that include the Chamber of Commerce, Kampala Arcade Traders Association, Kampala City Traders Association, Uganda Small Scale Industries Association, Uganda National Traders Association, the Gen Z Business Owners Association, Innovation Village, the startup ecosystem, and the independent private sector consultants. We did not stop there. We entertained financial, insurance, economic sector actors. These include the sector-specific institutional stakeholders that include Uganda Bankers Association, supervised financial institutions like banks, mobile money operators, via sector submissions. We also entertained Payment Service Providers Association. We also entertained Uganda Forex Bureau and Money Remittances Association. They too appeared and gave their views. We also considered digital, telecom, media actors in communication, broadcasting, and digital economy, include communication sector operators, National Association of Broadcasters, media practitioners, journalists, and journalism practitioners. We also entertained the civil society and non-government organizations, both domestic and international civic actors that include Anti-Corruption Coalition of Uganda, Foundation for Human Rights Initiative, Legal Aid Service Providers Association, the Rotary of Uganda, Women Pro Bono Initiative, Country Directors of International Network, and various national NGOs also submitted. We also entertained international organizations and development actors under these multinational organizations and international cooperation actors. These include United Nations Country Team, international NGO community, collectively represented. We did not stop there, Right Honorable Speaker and honorable colleagues. We entertained the labor, religious, and social institutions that include NOTU, that include Interreligious Council of Uganda, that include Muslim Organizations Coalition, and other faith-based organizations. We entertained health, scientific community, and public health research institutions, e.g., Uganda Medical Association, Uganda Virus Research Institute, Peoples Living with HIV advocacy groups. We also entertained education and academic sector that include Makerere University Academic Staff Association, universities and academic researchers, student groups, and members of the guild also submitted. National Union of Disabled Persons of Uganda, Uganda Lawyers Voice on Climate Change, Gender Rights and Advocacy, Climate Advocacy groups. We also entertained diaspora, transnational communities, Ugandan actors, the Global Forum. This is an organization that groups all Ugandans in the diaspora. The Cheyo Association, NUP, NUP Diaspora Chapter, individual diaspora submissions. We went further and entertained professional and individual submissions. These are unaffiliated and cross-cutting. Independent consultants, individual citizens, business professionals, researchers. Right Honorable Speaker, we consulted documents. Consequently, the committee recommendations reflect a balanced synthesis of stakeholder perspectives in the key findings and salient observations. Right Honorable Speaker, permit me to present key findings and salient observations on the Sovereignty Protection Bill of 2026. Introductory consideration, looking at the scope and interpretation of Clause 2. Before presenting its findings, the committee found it prudent to clarify the key interpretive issue of Clause 2, which is application of the bill. Clause 2 sits at the core of the legislative framework, and it defines the reach of the law and it determines who is regulated and what circumstances and for what conduct. The committee reviewed the Honorable Attorney General's comments, noting that Clause 2 limits the bill to specific activities tied to foreign influence. According to the learned Attorney General interpretation, the bill does not apply to a person generally, to all persons generally, that it applies only to persons acting as agents of foreign actors, and that even then, only where such a person is engaged in specific conduct, including influencing government policy, political processes, or public decision-making for the interest of foreigners. The Attorney General clarified that Clause 2 is meant to limit the bill, not to expand it. He guided that it applies only to agents of foreign actors and only when they engage in specific influence-related activities, e.g., affecting government policies or public decision-making. In addition, the learned Attorney General noted that the bill is activity-based, not identity-based. So ordinary transactions like remittances, businesses, family support are excluded unless tied to regulated influence. On this reading, the bill presented a targeted regulatory instrument aimed at structured foreign influence operations rather than legitimate international engagement. However, the committee observes that this interpretation, while persuasive as a matter of policy intent, is not shared by the majority of stakeholders. There is a gap between the AG's intended narrow scope and how the bill is actually drafted. When Clause 2 is read together with broad definitions in Clause 1 and the expansive list of activities, including concepts such as influencing public opinion and activities that the minister may prescribe, stakeholders interpreted the bill as having a much wider practical effect. The East African Law Society, for example, in their submission, warned that the term agent of a foreigner in Clause 2 could apply to regular economic, professional, and family connections, such as employees of foreign businesses, traders, and those receiving support from relatives abroad. The Law Development Center noted that in Clause 2 does not distinguish harmful actions from lawful ones. So the people could be held liable simply because of their associations, not because they caused any actual harm. This divergence, Right Honorable Speaker and Honorable colleagues, reveals a fundamental issue. The intended limitations of Clause 2 are not sufficiently clear on the face of the law, creating uncertainty as to the boundary between harmful foreign influence and legitimate activity. While the Attorney General maintains that Clause 2 limits application to specific regulated activities, stakeholders consistently note that this limitation is not clearly reflected in drafting. Therefore, the committee found that the line between harmful foreign interference and legitimate activities is unclear. Clause 2 is meant as a safeguard, but not effectively to limit the bill. This gap policy and the law shapes all the committee's subsequent findings. 5.2, understanding sovereignty. We looked at what the 1995 Constitution says versus what the bill proposes. Sovereignty under the 1995 Constitution as amended. This committee discussed sovereignty referencing the Constitution of the Republic of Uganda. Herein
Yes, ka network akakutemu, but that is the situation you've been following, I guess. Era nga buli kimu ndowooza mukigoberera bulungi. Ndowooza ye speaker mumanyi temwewuunya, n'ekirala abadde balinamu enkenyera nti oba gavumenti eyinza okukwatibwako oba kale ensonyi oba neebaako ekyenjawulo kyekola. Beerako buli kimu okigoberere bulungi. Yabeerako buli kimu okigoberere bulungi.
with the people and security dimension where the state exercises authority to safeguard national interest. We looked at a leading jurist, Justice Oliver Wendell Holmes, Jr., 1841-1932, a renowned American jurist who served as a Supreme Court judge, who described sovereignty in similar terms. Justice Wendell Holmes perceives sovereignty as the ultimate practical power of the state to govern and maintain order grounded in the historic and social necessity for societal existence and survival. The state action is therefore legitimate only when it maintains grounded in popular sovereignty. Guided by this understanding, Honorable Speaker and Honorable colleagues, the committee observed that the bill introduces a strong emphasis on shielding Uganda from foreign influence and expands the state's regulatory powers over political and civic activity. Summarily, the bill aims to protect the sovereignty of the people, prevent foreign interference on governance, and the key features include restricting activities that promote foreign interests, which can be gotten from Clause 5, restricting non-state actors from performing government functions, which is Clause 6, criminalizing interference in elections and government operations, which is Clause 1 to 13, and regulating foreign funding and civil society activities, and restricting interference.
Is it 1 or 11 to 13?
11, I beg your pardon. 11 to 13. Restricting interference of government policy. The committee, therefore, found that the Constitution grants ultimate authority to the people, with the government acting as a trustee. The Protection of Sovereignty Bill 2026 regards the state as primary guardian of sovereignty and adopts a cautious approach to foreign-linked actors. Whereas the Constitution vests sovereignty in the people of Uganda, the bill focuses on the protection of sovereignty through state action, reframing sovereignty in the security terms and promoting stricter regulation of foreign influence. We looked at broad definitions and the scope. The committee found that the bill definition of foreigner and the agent of a foreigner are overly broad. And as defined in the bill, it wrongly includes Ugandans living abroad. It wrongly includes students. It wrongly includes researchers. It wrongly includes professionals working in international partners. It wrongly includes government ministries, departments and agencies exercising regulatory authority under any act of parliament, and organizations and companies that simply have foreign investors or cross-border businesses. Instead of targeting harmful foreign interference, the bill inadvertently ends up covering normal economic, academic, and community activities. This, Right Honorable Speaker and Honorable colleagues, blurs the line between harmful foreign interference and ordinary lawful activities. It making everyday economic, academic, and civic engagements legally risky. Clause 1 and 2 are specifically powerful in determining who is regulated and punished, and even raising constitutional questions about citizenship by classifying Ugandans abroad as foreigners. Stakeholders warned that this could criminalize normal cooperation, such as research, education, and diaspora support. In fact, the Law Development Center has termed it as regulatory contamination, where indirect foreign links extend liability across entire economic and social chains. The committee therefore recommends, 1, that to restore legal precision, to ensure proportionality, and to align the bill with constitutional principles and practical realities, the committee recommends the following. Amend the definition of a foreigner to limit it to non-citizens and foreign registered companies. Amend the definition of agent of a foreigner to only include people who formally and knowingly act on behalf of a foreigner to influence public policy, elections, or national security. Insert new definitions of words and phrases used in the bill to improve clarity. Insert an intent requirement, which the land colleagues call mens rea, so liability only arises with deliberate influence. 5. Insert a clause explicitly protecting legitimate economic, academic, humanitarian, developmental, and civic activities to prevent misinterpretation and ensure lawful activities are not captured by the bill. 5.4, creation of a parallel regulatory regime. The committee observed that the bill creates a new approval and monitoring system under the Ministry of Internal Affairs. However, many sectors in Uganda are already tightly supervised by strong regulators, these include Bank of Uganda, Financial Intelligence Authority, the Uganda Communications Commission, the Insurance Regulatory Authority, and university councils. Stakeholders argued that the bill repeats work already done by these regulators and may create conflicting rules instead of improving oversight. This duplication can lead to confusion about which rules apply, multiple reporting requirements, and uncertainty for businesses and institutions. For example, both telecommunications and banking sectors already operate under strict regulatory systems. Adding another regulator with similar powers could disrupt systems that are currently functioning well. The committee notes that these sectors are already governed by detailed laws and licensing frameworks. Stakeholders also warn that the bill could create a parallel system, quote unquote, run by a security-linked department that may not have technical expertise of existing regulators. Media organizations, too, pointed out that the issues such as foreign funding, transparency, external influence are already addressed under current laws, including anti-money laundering legislation and the NGO regulation. The private sector representatives highlight the economic impact of the bill, more uncertainty, more regulators to certify, and higher costs of doing business. Stakeholders caution that the bill risks creating duplication, institutional conflict, and opportunities for forum shopping. The committee recommends, therefore, that in light of these concerns, the committee recommends that all institutions and individuals already supervised by a regulator established under an act of parliament should be exempted from the bill. Concentration of executive power in the minister. The bill gives the minister responsible for internal affairs wide and layered powers. These include authority to 1, define the key terms used in the law, 2, approve or reject the foreign funding. 3, register or cancel organizations, and determine how the law will operate through regulations. The committee notes that while each of these powers may be common in isolation, their combination in a single office creates a system where participation in economic, civic, or institutional activities depends heavily on the minister's approval. This raises a deeper constitutional concern, not just about administrative efficiency, but about the overall design of governance. The committee elaborates these issues under 3 major themes, from regulatory oversight to discretionary control, where stakeholders observed that the minister's power and the role goes beyond implementing the law. The minister effectively controls access to the law itself, and the minister can decide who falls under the law, who controls access to funding, grant or withdraw the legal status, and shape how the law functions in practice. This, we noted, it risks turning the framework into permission-based system where individuals and organizations must seek approval to operate instead of following clear, predictable rules. It also has constitutional implications. This concentration of authority raises significant constitutional concerns. It weakens the separation of powers by placing too much control in one office. It reduces checks and balances from independent institutions. It increases the risk of unfair or arbitrary decisions, especially where the bill lacks clear procedures, timelines, or appeal mechanisms. A system that relies on discretion rather than clear rules undermines legal authority. No, I beg your pardon, undermines legal certainty and public trust. We also looked at reframing sovereignty. The committee notes that many legal and governance submissions view this more than an administrative matter. They see it as a shift in how sovereignty is exercised. Instead of power flowing through established institutions and the people, it risks being concentrated in one single office. From human rights perspectives, any limitation on rights must meet 3 tests. 1, legality, necessity, proportionality. The bill does not clearly demonstrate how these standards are satisfied. We therefore recommend. The committee recommends that to preserve the bill's objective. I beg. Can I conclude? Thank you. Let me read. Thank you, Right Honorable Speaker.
How many minutes do you want to conclude?
Yeah. I need 5 minutes and I conclude.
5 minutes. I'll add the other side also 5.
Okay. The committee recommendations. To preserve the bill's objective while restoring institutional balance and constitutional compliance, the committee recommends the following amendments. 1, limit the application of the bill to honorary agents of a foreigner. Exclude the application of the bill to Ugandan citizens residing outside Uganda. Remove the power of the minister to declare any person a foreigner. Remove the restriction on recruitment and employment of a person who are abroad from disruptive activities. Provide for the elements of an offense. Avoid unnecessary bureaucracy in the implementation of the policy. Replace ministerial approvals with the declaration of funds to the relevant regulator. We looked at disruption of financial and economic systems. We also have recommendations. On that one, to safeguard national interests without disrupting financial systems, the committee recommends shifting from broad approval-based controls to a targeted risk-based approach by 1, protect everyday financial flows by exempting personal remittances, routine banking transactions, and legitimate business financing. Replace blanket approvals with disclosure requirements, reserving prior approval only for high-risk activities such as funding linked to political influence. Adopting a flexible risk-based declaration system developed with financial regulators and aligned with existing anti-money laundering frameworks. We looked at the vagueness and criminalization of risks. Right Honorable Speaker, we recommend that we align the bill with constitutional requirements of legality and certainty. The committee recommends the following amendments under vagueness and criminalization risks. The committee recommends clearly define all criminal offenses, specifying prohibited conduct and the required intent and the harm addressed. Reduce the penalty of 20 years to 10 years and a fine in the case of legal entity for 200,000 currency points to 1,000 currency points. Limit offenses to conduct that poses a real and a demonstrable threat to national interests, avoiding broad terms that may capture lawful activities. Include measurable thresholds or criteria such as scale or impact to guide enforcement and reduce subjective judgment. Insert a saving clause to protect legitimate activities such as business operations, research, journalism, advocacy, and civic engagement. Introduce procedural safeguards, including enforcement guidelines, written reasons for decisions, and access to administrative or judicial review. We looked at the impact on academia, health, and innovation systems. And we recommend that the academic institutions, research bodies, health and medical facilities legally operating in Uganda be exempted from the bill. We examined the certificate of financial implications because this is a requirement of Public Finance Management Act. We looked at the cost. Right Honorable Speaker, we interrogated it actually. The details are there. We concluded that, therefore, since in conclusion, Right Honorable Speaker, in conclusion, the committee undertook extensive consultations, and the views received reveal a shared concern. Across all submissions, there is broad agreement on 4 key points. The bill's objective is legitimate, but the definitions and applications are overly broad. The regulatory approach duplicates existing legal institutional frameworks. Excess power is concentrated in the minister, and the bill's impact could extend across entire economy. In response to the above and the concerns, we interacted with the learned Attorney General again. And now we conclude that the committee, therefore, recommends that the bill proceed to second reading, subject to proposed amendments attached thereto, and any further improvements this August House may consider appropriate.
Honorable.
Right Honorable Speaker,
I want this part where you interacted with the Governor of Bank of Uganda.
Okay. In response to the concerns, the Attorney General proposed areas for review, which were supported by the Bank of Uganda. The committee has carefully considered these proposals. We have also incorporated these amendments where applicable in the bill. I want to report that, yes, we interacted with the Governor Bank of Uganda actually twice. After we had gotten proposals, we flashed to him, and the Governor Bank of Uganda also agreed with the committee and sent us more amendments, which we incorporated.
Thank you.
I need to report.
Thank you.
I need to report, however, that this majority report that was signed by more than 3/4 membership also has minority reports. In fact, because it's my duty as the reader of the majority report to report the House that we have 5 minority reports. 5 minority reports.
Are there 5?
I beg to report,
Thank you.
Honorable Speaker.
Thank you. Can I have now the minority report? Thank you. Thank you. Thank you.
Right Honorable Speaker, I present this minority report, and we have agreed with our colleagues who also dissented that this will be the order of presentation. I will present first, followed by Honorable Wilfred Niwagaba, to be followed by Honorable Gilbert Olanya, to be followed by Honorable Abdallah Kiwanuka, to be followed by Honorable Betty Namboze, and lastly, the Honorable Medad Segona Lubega. And we have
and the rules of the time still apply.
Before I begin to present, if you may allow, I can address you on that. When a member of a committee dissents singularly, the weight of the report demands that we be accorded the same time frame, Madam Speaker.
Which rule is that? Which rule is that?
Under Rule 215, Sub-Rule 3, it says that a member dissenting or members. And the reasons are in this report, Madam Speaker, you'll see. If I may address you briefly, in the committee...
I am giving you 35 minutes.
This is
all of you. Honorable members, before we continue, we have Honorable Tim Bernard from Maruzi. Welcome, Honorable Tim. And then Honorable Tibiase Peace from Jinja. Welcome. And here, join me in welcoming our new members. Yes.
This is a minority report, Madam Speaker, in substantial dissent of the majority report of the Committee of Defense and Internal Affairs.
Honorable members, can we listen to the report?
And the Committee on Legal and Parliamentary Affairs on the Protection of Sovereignty Bill 2026. This minority report is brought under Rule 215 of our Rules of Procedure of Parliament. In the opening remarks, Madam Speaker, it is critical that today, when a draconian bill is presented to this Parliament for enactment into law, the minority is persuaded by some of the most memorable speeches in the political history of Uganda. Honorable members of Parliament, please pay attention to the contents of this speech attributed to President Yoweri Kaguta Museveni in the early 1990s. This is what he said. I open the quote. Depending on the nature of the state, in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It is not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave trade period, enslaved people were owned and disposed of like chattels, and it was perfectly legal to own a slave. The NRM government is strongly opposed to having laws on our statute books which serve the interest of the minority against the majority of the people, or in which any way promote to serve the injustice or advance backward interest in our society. We close the quote. The minority shall, where necessary, refer to the speech above for the purpose of reminding ourselves as legislators and fellow Ugandans. And 4,
Right Honourable Speaker. But we want to benefit from the citation. When you're citing, you're quoting somebody, you've stated the date, you could also tell us where that speech was
You
made.
can find the source.
Right Honourable Speaker, I am well conversant with the rules of procedure of this House. That's why I've confined myself to this report. I will be available to clarify if necessary. Members can listen, I will respond to you. Thank you. The minority report, where necessary, shall refer to the speech above for the purpose of reminding ourselves as legislators
Can I
and
have
fellow
a chance to have a
Ugandans.
copy? Can I have a copy? Yeah. Me, I don't. Me, I'm analog.
And fellow Ugandans, for we have come from the far, we have come, and the apparent U-turns and reversals that are being made for whatever reasons being advanced, which reasons have no place in shaping the sovereignty of the people of Uganda. Areas of dissent and statement of reasons for dissent. Area 3.1, violations of the rules of procedure of Parliament. Madam Speaker, during the consideration of the Protection of Sovereignty Bill 2026, the co-chairpersons violated several provisions of the rules of procedure of Parliament of Uganda. Rule 135 of the rules of procedure is instructive on reference of a bill to the committee as follows. Sub-rule 1, whenever the bill is read for the first time in the House, the bill shall be referred to the appropriate committee appointed under these rules. Sub-rule 2, the committee shall examine the bill in detail and make all such inquiries in relation to the bill as the committee considers expedient or necessary, and report to the House within 45 days from the date the bill is referred. 3, except in the cases of very minor amendments and subject to Rule 138, all proposed amendments to a bill referred to the committee shall be presented to the committee by the person proposing the amendment, and the committee shall scrutinize the amendment together with the bill. 4, the committee may propose and accept proposed amendments in the bill as the committee considers necessary, if the amendments, including new clauses and new schedule, are relevant to the bill. The minority observes that the committee violated sub-rules 2 and 3 in as far as it did not examine the bill in detail and further did not make all such inquiries in relation to the bill. In the view of the minority, the decision of the committee through a vote on a motion by Honorable Fox, Odoi, or Yelowo for an omnibus adoption of all clauses of the bill and the amendment by the learned Attorney General without examination and inquiry violated Rule 135. The minority, Madam Speaker, also observed that the Protection of Sovereignty Bill 2026 was proposed by the Minister of Internal Affairs, Major General retired Kahinda Utafire. Sub-Rule 3 restricts the latitude to propose substantial amendment to only the mover of the bill, which is the Minister of Internal Affairs. Only minor amendments may be proposed by any other person who is not the proposer to the bill. With all due respect, the learned Attorney General proposed 18 amendments, all quite substantial in nature, which amendments the majority unilaterally adopted and relied on to pass the bill in the committee. The committee sought to have rejected the committee ought to have rejected the substantial amendment proposed by the learned Attorney General outrightly. To even make it worse, Madam Speaker, the new amendments were laid before the committee in form of a new bill. Rule 135, Sub-Rule 1, confines the committee to a bill read for the first time in the House and referred to the committee. The committee is stopped from directly receiving bills not read in the House and referred to it by fraudulently bypassing this House and smuggling an amended version of the bill to the committee, an illegality that goes to the root of parliamentary procedure and practice was committed and cannot be cured by any explanation at all. Madam Speaker, the minority further observes that no sooner had the learned Attorney General purported to present the amended Protection of Sovereignty Bill 2026 to the committee at about 12 noon on Thursday, 30th April 2026, than His Excellency the President, through his address to Ugandans at about 4 p.m. on the same day, withdrew instructions from the learned Attorney General. Instead, President publicly assigned Honorable Dennis Amson Obua to ensure that the bill concentrates on what he calls sovereignty of policy decision making. In the practice of law, there is nothing professional as humiliating as a client withdrawing instructions from you and sharing it out with the public outright. No wonder, since then, neither the Attorney General nor the Minister of Internal Affairs ever attempted to appear before the committee or the House. The House must therefore not entertain the two on anything to do with the Protection of Sovereignty Bill 2026, since the President withdrew the vote of confidence in them. The minority, Madam Speaker, formed the view that Honorable Obua Hamson, having been given fresh instructions as per the written expression of the President, ought to have immediately sought audience with the committee to present the instructions given to him. Was it an instruction to withdraw the bill, or what was it? Despite the insistence of the minority to invite the Honorable Hamson Obua under Rule 135 Sub-Rule 2 to make all such inquiries in relation to the bill, as this was the most expedient, the co-chairpersons, Honorable Kajwenje Wilson.
Honorable Jana, sorry for interruption. My presumption is that when you bring a minority, you bring your points of departure, not procedure. Flavia, points of departure, not a debate on the procedural ways.
Madam Speaker, respectfully, this is one of the points of departures that I had.
Which one? Which one?
Under subheading 3.1, I said areas of dissent and statement for reasons of dissent as provided in the rules. The first was violations of the rules of procedure of Parliament. And I am explaining under Rule 135 that the committee ought to have examined and on its own move to go and inquire, to make inquiries. And my point is, having come to the attention of the committee that Honorable Obua Hamson was assigned, the committee ought to have moved itself to request Honorable Obua to come and substantiate. It goes to the root of my dissent, Madam Speaker.
So the committee instead went to Honorable Obua. Oh, they should have.
Thank you, Madam Speaker. The co-chairpersons were evident. Madam Speaker, this is important. The co-chairpersons, Honorable Kajwenje Wilson and Honorable Baka Mugabe Stephen, were evidently partial, hostile, and continuously switched off the microphone of members in the committee they perceived to be against the bill. Contrary to the established practices of availing physical copies of submissions of stakeholders to members of parliament at the retreat, members of parliament were instead told to physically get copies to members of parliament. Instead were told that physical copies could not be availed since parliament was on a weekend. The views of Madam Speaker, views of selected stakeholders were instead sent to members on WhatsApp to read on their phones. Members who were not on WhatsApp or whose phones could not open the WhatsApp were effectively denied critical document. Madam Speaker, the privileges of a member of parliament were violated to the extent that some of the members of the committee had to jump on border to travel to Nassau Road to print the stakeholders' document for their own reference. A passionate plea for the committee to adjourn until Monday, when parliament is open, for purpose of printing or photocopying the document was turned down. But Right Honorable Speaker, this gross.
I am rising on a point of procedure. Madam Speaker. A minority report, as per our rules, envisages that a member participates in the proceedings of a committee and then disagrees with some of the decisions taken by the majority. You read. But not to come here and tell us stories, how the committee... So, no. Read the rules. This parliament, while debating reports, is not for storytelling, how members were seated, how they were reading, going on border. What we expect, Madam Speaker, from the minority report is where the member disagrees with the decisions of the majority report, not to waste time of parliament talking as if he's just reading a story. So is the honorable friend of mine proceeding correctly by wasting our time as parliament instead of being straight.
Honorable Dur, Jonah, I am actually enjoying your story. You continue with the story. Please. Let's continue. Let's listen to the story.
Thank you. Right Honorable Speaker, this gross abuse of authority with utmost impunity, laced with shameless sycophancy, is highly condemned. Presiding officers in committees and indeed plenary must be impartial, patient, and respectful of the constitutional rights of an MP to represent their constituencies without undue partiality and interruption. I must also add that the co-chairpersons of the committee appeared not to have addressed their minds to the rules of procedure of parliament which guided us, and opted for personal whims to decide substantive points of law as well as procedural matters that arose in the committee. My finding number one is that the proceedings of the committee were held in complete violations of Rule 135 of the Rules of Procedure of Parliament. 2, the co-chairpersons exhibited gross incompetence, lack of tolerance for divergent views, and stifled all avenues of debate during consideration of the bill.
Honorable Dur, incompetence. By the time you come and be a member of parliament in this house, let's tone down our language. Let it be parliamentary. Even when I'm enjoying your story, at least let's be parliamentary. These gentlemen are competent.
Speaker, I don't want to go into the debate, but I could have addressed you on the around competencies. But let me continue. Recommendation. And it's in writing here.
And I will remove it on the issues of competence.
You are
I
such
will
a powerful
remove.
person. Please, Madam
Yes.
Speaker, I respect. Please proceed
Yes,
and remove.
please, you go ahead.
The
I will remove
minority
that.
recommends to Parliament to reject the majority committee report and instead refer the bill to the executive, or in the alternative, but without prejudice, be pleased to appoint another committee to examine the bill in detail and make such inquiries in relation to the bill in full confidence. Dissent number 2, defective certificate of financial implication. The minority observed that the certificate of financial implications issued by the Ministry of Finance, Planning and Economic Development does not comply with Section 76 of the PFMA and Rule 124 of the Rules of Procedure of Parliament. Section 76 of the PFMA and Rule 124 are at par on the certificate of financial implication of a bill as follows. 1. Every bill introduced in Parliament shall be accompanied by a certificate of financial implications issued by the Minister. The certificate of financial implication issued under Sub-Rule 10 Sub-Rule 1 shall indicate the estimates of revenue and expenditure over a period not less than 2 years after coming into effect of the bill when passed. In addition to the requirements under Sub-Rule Subsection 2, the certificate of financial implication shall indicate the impact of the bill on the economy. Notwithstanding subsections 1, 2, and 3, a certificate of financial implication shall be deemed to have been issued after 60 days. The minority examined the certificate of financial implication issued on 15 April 2026 by the Ministry of Finance, Planning and Economic Development, signed by Amos Lugolobi, MP, Minister of State for Finance, Planning and Economic Development. In the certificate, under paragraph 5 on impact of the economy, the Honorable Lugolobi states as follows: the proposed bill is expected to strengthen Uganda's policy autonomy and national security architecture, improve coherence in the management of foreign aid and foreign funded activities, and support stability in governance and public order. These outcomes are expected to contribute to a more secure environment and implementation of government programs and long-term national development. The minority draws the attention of honorable members to the sad realities that has befallen this country, that the entire ministry responsible for finance, planning and economic development does not know what constitutes an economy of a country called Uganda, and therefore are unable to articulate the impact of the bill to the economy of Uganda. The minority observes that instead of assessing the impact of the bill against well-known parameters such as GDP, sovereign debt to GDP ratio, balance of payments, central bank reserves, interest rates, inflation, exchange rates, rate of growth, etc. Alien parameters form the basis of the assessment. The observation by the majority report that the certificate of financial implication met the statutory standard.
Honourable members.
Let me just put on record.
Yes.
This minority, which I wrote, is actually.
Let's capture all what has been in all the minorities.
This is what exactly
so
happened
how
in
much,
the committee.
let me
that
give
were
you
not
2
heard.
minutes. Let's give you 2 minutes.
This report I have is 40 pages.
Let me give you 3 minutes to summarize.
And in the committee, the same treatment, Madam Speaker, who are not heard. That's why I'm bringing this issue. I'm appealing to the House.
I have actually given you the same amount of time, 2 minutes. You conclude.
Madam Speaker, I want to put on the record that I cannot conclude in the 3 minutes you have given me, but I appreciate it. If it is your ruling that this report stops at this level, I have no problem. I respectfully submit, and then I can leave, because there is no way I can. And I wanted just to finally, because as you also know, this may be possibly the last time some of us may be in this parliament. So I wanted you to protect that constitutional right, that little window that the people gave me to be in this house, to represent them. I just plead of you. I may not come back ever, but that constitutional right for me to present, I wanted to ask that you give me.
Jonah, because you've actually spent the 35 minutes. Now, Jonah, I have always told you you're one of the people I will miss in this house. I am giving you an additional 5 minutes, and all the other minority reports, we will capture what is in your minority report, because the time has been taken.
Yes. Yes. You merge your reports. They merge their reports.
Right Honorable Speaker. Thank you so much, Right Honorable Speaker. I want to now go back to the report, but let the record capture that when I appeared in the committee, and you have designated me, Madam Speaker, as a member of Parliament to sit in the committee of the legal. In the joint committee, I was not given the opportunity. The same treatment, and that's why I thought this house would allow me to present. So with that, let me just put on the record that that the 5 minutes that you have given to me is not enough for me to present this, and I thank you, and probably take the opportunity to conclude by wishing members who are going to return to the 12th Parliament good luck in their deliberation and representations. I know next week people are going to swear in. I want to wish you all the best, but without prejudice, if the committee proceeds to committee stage, the amendments that are also attached here.
Yes.
I beg that I will be given time to move those amendments, Madam Speaker.
So you're putting a motion for committee stage so that we do the amendment?
Let the record capture that I did not. I just put your note because I'd written it here.
No problem. We shall consider
If you had been patient and read, it was going to come in the last page.
No, I am not impatient. Honourable members, I gave each side 35 minutes.
Yes. Right Honourable Speaker, I believe you will give me my right as a member who prepared a minority report that was co-signed by 2 other members, Honorable Adeke Ann Ebaju for FDC, District Woman Representative for Soroti, and Honorable Asumani Basalirwa, the MP for Bujiri Municipality. And my Right Honorable Speaker, our points of dissent are in the following areas. 1, the provisions in the bill that tend to infringe the freedom of expression, contrary to Article 29 of the Constitution. 2, the inconsistent mens rea, since several offenses of comparable severity, particularly clauses 8. Incidentally, this particular microphone seems to have been tampered with, and mine has, so, clauses 8, 10, and 12, and 22, that remain strict liability, while others require intentional knowledge, and creating an internal inconsistency contrary to Article 28(3) of the Constitution. I hope the answer will capture me. Yes. At Satura number 3, Satura definitions in respect of foreigner and agent of foreigner, which cross-refer to clause 2, which in itself raises legal certainty.
Wilfred, that we will discuss that at committee stage. I will allow you to bring your issues.
Number 4, Right Honorable Speaker, is on criminalization of free speech. Number 5, and most importantly, Madam Speaker, this particular bill tends to infringe Article 1 of the Constitution by 1, trying to invert the sovereignty of the people into the sovereignty of the state. Article 1 of the Constitution refers to the people of Uganda being sovereign. What the state has is the authority to administer. So the title of the bill itself tells the lie about itself. And when you go through the bill, Right Honorable Speaker, apart from clause 5, which talks about the sovereignty of the people of Uganda, the rest of the clauses are in respect of the sovereignty of the state.
Okay.
And when we go to committee stage, Madam Right Honorable Speaker,
So we are going
have many amendments to make.
No problem.
Since we were never given an opportunity in the committee stage,
Thank you.
we have amendments to make on almost all clauses in the bill.
Thank you.
May I invite my other colleagues who have minority reports to make their
members.
presentations.
Members.
Thank you.
Madam Speaker, I have something to tell you. Madam Speaker, in my capacity as the Shadow Minister for Internal Affairs, I went to the committee with a request to make a presentation. Madam Speaker, I happened to arrive before the Attorney General. The chairman of the day, Honorable Baka, requested me to wait for the Attorney General to present so that I could also be given time. After the Attorney General had made his presentation of amendments, Honorable Baka ruled that I will make my presentation while at Munyonyo. When we reached Munyonyo, Madam Speaker, Honorable Kajenje ruled that my request had been overtaken by events. Madam Speaker, I chose to write a minority report because the issues I was going to raise had not been raised by anybody else. So I wrote a minority report, Madam Speaker. Madam Speaker, you are now ruling that there is no time. Madam Speaker, as a member of the committee, I'm not supposed to debate. Madam Speaker, there was a memorandum that came from Buganda Kingdom. Madam Speaker, when we reached Munyonyo, the memorandum went missing. Madam Speaker, they have told you here. Let me tell the Speaker. Madam Speaker.
Honourable members, give Betty time. Some order.
Madam Speaker, I've heard the chairman telling you that when we were at Munyonyo, we heard from the Governor Bank of Uganda. And you know, Madam Speaker, I was so surprised because while the rest of us were in Munyonyo, we were never informed that even the Governor of Bank of Uganda had gotten back to us. Madam Speaker, because of those many issues, we are also told that 700 people sent memorandums to the committee, but only 47 of them were accounted for. I feel so silenced. Is it your ruling that the people from Mukono should not be heard on this?
Honorable Betty. Honorable Betty, my sister. The people of Mukono have been heard. You've spoken for over 5 minutes. You've raised your issues, and we are going to address all of those issues. Honorable members, Honorable members, we have all these supplementaries. And not supplementary, but minorities. We are going to go committee by committee. And all of you are saying you have issues on each clause. Why don't we look at clause by clause? Honorable Odur has raised pertinent issues. Let's look at.
Madam Speaker, let
Yes,
the record be clear.
Honorable
You denied me opportunity to present. Don't use my name. Don't use
Honorable
my name. No, don't.
Honorable Dul, you took all the 35 minutes. Honorable Honorable Lanya.
Right, Honorable Speaker.
Honorable Lanya, let me give you 5 minutes.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I'll go straight to the point of dissent. Right Honorable Speaker, the minority, following Rule of Procedure 105 of Parliament, Right Honorable Speaker, the bill establishes an extensive regulatory and criminal framework governing individuals and entities classified as agents of foreigners, imposing control and funding policies, policy engagement, and civic participations. The minority observes the several provisions, raise several concerns, including the vagueness and inconsistency of definitions, an extreme and disproportionate penalty regime, infringements on freedom of expression and civic space, duplication of existing legal framework, and the absence of commencement and the transitional provisions and duplications of the existing legal framework. Right Honorable Speaker, when the committee engaged with many entities, you recall we engaged with about 53 entities. Out of the 53 entities, 52 were in support of this bill. 51, including Bank of Uganda, religious leaders, among others, were telling Ugandans that this bill, when passed, it will create economic instability in Uganda. That was the word from the governor of Bank of Uganda. Right Honorable Speaker, this bill, it creates extreme and disproportionate penalty regime. The bill establishes a uniform and severe penalty structures, imposing custodial sex sentences of up to 20 years in prisons across wide range of offenses. Notably, the same maximum penalty applies to promotion of interest of foreigner. If you look at clause 5. Right Honorable Speaker, participation in activities deemed to promote foreign policy. That is in clause 10. Publication of information characterized
Gilbert,
as
we have
economic
now
supplement.
we have gone to clauses.
Thank you, Right Honorable Speaker. Right Honorable Speaker, because of time, let me go straight to the recommendation. Right Honorable Speaker, this minority came out with the following recommendations. Having engaged and got many views from Ugandans, the minority recommends that the House does not pass the bill in its present form. 2, the bill be withdrawn and remitted for comprehensive redrafting. 3, a proportionate penalty regime aligned with existing legal frameworks, be supported by a credible economic and physical analysis, and finally, be subjected to broad stakeholders' consultation. Right, Honourable Speaker, the view of the minority is that the bill should be withdrawn. I beg to move.
Honourable Betty. Betty, 5 minutes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the points of my dissent are as follows. 1, Right Honourable Speaker.
Switch on. Switch on.
Right Honourable Speaker, it is my opinion that there hasn't been enough public hearing according to this bill. Right Honourable Speaker, you have been told that 57 memorandums were reviewed. But the fact of the matter, Right Honourable Speaker, is that the committee received over 700 memorandums. One of them, Right Honourable Speaker, as I have put it, being from the Uganda Kingdom. Right Honourable Speaker, when we went to Muwonge, we are given time to go and study these memorandums on WhatsApps. But when we returned to the committee, Right Honourable Speaker, the committee did not give us time to make a presentation, as I've told you before. Right Honourable Speaker, it's not about allowing people to come to the committee. The purpose of the people coming to the committee is to give their opinion space that the people should be heard. But we are handling, my point of dissent is that the committee ruled in favor of only 2 people out of the 700 who opposed the bill, Right Honourable Speaker. Right Honourable Speaker, we are here fidgeting with time. This is not legislation. The committee is always given up to 245 days, according to our rule of procedure 135.
Not 200.
45
days. But if you get a committee which is efficient like yours, it can even do it.
It wasn't efficient, Madam Speaker. Even the problem of time can even be seen while we are here, Right Honourable Speaker. Right Honourable Speaker, my request is that the 11th Parliament stops behaving as if it is the last Parliament Uganda will ever have. There will be other parliaments that will come after this Parliament, Right Honourable Speaker. And Right Honourable Speaker, we are so honored that you will also be in that next Parliament, Right Honourable Speaker.
No, I can.
My recommendation, Right Honourable Speaker.
I can choose not to be because I have.
You already there because we have been talking to Mau.
How has Mao come here? Order. There's an order here. There is an order.
Right Honourable Speaker. Right Honourable Speaker, we are discussing a very important bill. And I'm wondering how Honourable Member is talking about their discussion out of this House. Is it in order to bring the name of somebody on sovereignty bill that we are discussing? Is it really in order?
Do you want to tell us is that he's an agent of foreigners? No, the person they mentioned the name. Yes.
Right Honorable Speaker.
Betty, finish.
Right Honorable Speaker, the other point of dissent is on the issue of interpretation, Right Honorable Speaker. The law refers to the interest of Uganda. However, when you go into the interpretation, the interest of Uganda has not been defined. It also talks about the interest of the foreigner, which is also undefined. It also talks about government policy.
That is on interpretation
on
clause.
Interpretation, Right
so
Honorable
you will
Speaker.
bring your idea when we are in that clause.
I thought, Right Honorable Speaker, you had allowed me to present my report.
No, what I'm saying, we will expect your idea on that clause, what you think, the amendment you want.
Madam Speaker, first of all, I'm a member of the committee who is not supposed to contribute to debate.
No.
Two, Right Honorable Speaker, you gave me an opportunity to make a presentation.
Honorable
and
Betty,
I was so thankful that
Honorable
you gave me
Betty, I am only advising you that when we reach that clause, I will still give you chance to bring in. So you read your report, but I will still give you chance to bring your proposal.
My recommendation, Right Honorable
Are we speaking
Speaker.
the same English?
Madam Speaker, I'm reading the report and you are giving me advice. I take your advice, Madam Speaker, but I continue to read my report.
You read. Yes.
I seek for your protection.
You finish. You continue the report. Continue.
I seek for your protection.
Members, yes, there's an order from WOPA. Order from WOPA.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I want to request. Right Honorable Speaker, there is a lot of noise, and yet the microphones that they are using is not as loud. So, the point of order that I'm raising is that, is it in order for members to make noise when a member is submitting? Is it it's okay to laugh, but let us laugh and allow the member to read her report. We now can't hear what she's actually reading. So, Madam Speaker, is it in order for members to continue shouting when a member is actually reading her report?
You are the one who was shouting. Honorable Betty, can you? Let's hear Honorable Betty. Members, can we listen to Honorable Betty? It is on. Switch on.
Thank you, Right Honorable Speaker. I don't know why this particular microphone is low.
Please go ahead. At least I can hear you.
Right Honorable Speaker, my suggestion, my recommendation is that this bill is withdrawn by the movers to give Ugandans time to make meaningful contribution to the debate and to accord the Parliament enough time to handle a bill of this nature. Right Honorable Speaker, the Commonwealth practice is that parliaments which are about to retire don't handle controversial business. It's a practice, Right Honorable Speaker, and we are part of the Commonwealth, Right Honorable Speaker. The fact of the matter, Right Honorable Speaker, why that is required.
Which page are you in?
I'm reading page 3, Madam Speaker.
I'm not, and I'm following your report.
Madam Speaker, I move that this House finds that this bill violates the Constitution, rules of procedure, and the Parliamentary Convention, and that this House declares that the denial of the main report offends Rule 245 and 215.
214 and 215.
214 and 215. That it also declares that clause 2, 3, 5, 8, 11, 12, 24, 25, 30 are void for vagueness and the unlawful delegation of powers. That this Parliament rejects the joint committee report by the majority. I therefore also recommend that the movers of the bill withdraw the bill under Rule 141, defer the subject to the 12th Parliament with proper consultation, direct that any future bill must affirm the sovereignty in the people under Article 1, define all key terms.
First of all, Rule 141 is on procedure
141. Rule 140.
Sub-Rule 1.
Sub-Rule 1. That directs that any future bill must affirm that the sovereignty belongs to the people under Article 1, and that key terms in the bill are properly defined, that is, the interest of government, the government policy, what constitutes the actions that make one an agent of a foreigner, and that the minister is not given powers to alter the offences under the bill as it is in the bill, the law as it is in the bill. Madam Speaker, in conclusion, it is my prayer that the protection of the Sovereignty Bill 2026 fails the test of the constitutionality, legality, and procedure. The 11th Parliamentary Final Act should be to affirm the supremacy of the Constitution, not to legislate excessively. I so pray.
Thank you. Thank you. Yes, there is procedure matter from
Right Honorable Speaker, I want to thank you for the opportunity that you have given to those with the minority reports to present. It is in the interest of this country that all the voices of Ugandans are heard in this House. And those who have spoken represent those voices. Right Honorable Speaker, Honorable Jonathan Odur did say he wanted to make a presentation in the Muwonge, but he didn't have enough time. Or he was not given the opportunity. And now that he has very many issues that he would love to present, together with the rest of his colleagues, and those who may feel there are procedural matters that were not handled well, but now we have the opportunity to look at this bill in a proper detail, provision by provision. I beg to move procedurally.
So what have you spoken?
I therefore want to...
I am asking, what have you spoken?
Kiwanuka.
Kiwanuka.
I'm raising a procedural matter.
Kiwanuka.
Thank you, Right Honorable Speaker. briefly, but my approach was different. The point which
Let's have
Right
order.
Honorable Speaker. Notwithstanding the matter in which those amendments an affront to the past precedents of the House. Of the bill proposed additional amendments totaling to 24 out of 30 that are being proposed to this to the past ruling of the presiding officers of Public Service Pension Fund Bill, then directed the withdrawal of the Public Service Pension various precedents, including the Hansard of a bill. In reference to the Sexual Offences Bill 20, Minister to withdraw the bill and incorporate the proposals in the Pension Bill 2023. I guide that if a bill, incorporate the proposed amendments and have the bill changes, gazette it, critical amendments made in regard to this the bill. The minority wish to note that the amendment agreeable, amend the bill and reintroduce it the minority. Indeed, the Right Honorable Deputy Speaker, while directing in the minority report and those in the majority report their views and incorporate them into the virtue of Rule 8.2, in light of the above, the minority calls upon the presiding form part of the rules of procedure of
the ruling of the former deputy bill in detail and make all such inquiries working days from the date of the bill of the bill and the was an alteration.
To the other. Honorable Speaker, as the letter he wrote,
which bill
my right honorable Speaker, as I'm concluding, the minority notes that the resident of Fort Portal over his which was I call upon this House Sovereignty Bill 2026 that was read for the first which have been left behind. The report is that the government undertakes to be amended.
And they are great partners when it comes to making our laws when they present their views. In the presentation of the minority report by our honorable colleague Namboze, she mentioned twice that the views of Buganda Kingdom
I have
got
not.
lost.
I have not opened the debate yet. First,
I'm not.
First wait. First wait.
I was just saying.
First wait.
No, we wanted to be withdrawn from the Hansard. It is bad. Yes, we wanted to be withdrawn.
Honorable Daddy, you have only 2 minutes.
Right, Honorable Speaker, in the law that I studied, in that I taught some people, some of whom are in this house, there is room for accepting under protest. I want to accept some of your directions because you are the Speaker, but under protest. Number one is lumping me up with people I have opted to disagree with, and therefore saying, all of you minority, you are lumped up together and you are given the same time. That's number one. Number two, that even where you, Right Honorable Speaker, and with immense respect, do not contain your members. You allow them to present for more than the time you had originally apportioned for all of us. Then when I come, you say 2 minutes. I know that in my wisdom, collected by age, among other things, I am able to present this in those 2 minutes or 5. But I also know that the country will not benefit. With that said, Right Honorable Speaker, let me thank my colleagues that have presented before, both majority and minority. Let me also associate with the bulk of the minority presentations to avoid repetitions. Why I opted to disagree with some of them, including the minority, is that I did not read any amendment purportedly presented by the Honorable Attorney General. My construction and understanding of the presentation by the Attorney General, I read it, I know he skillfully wrote in small words views of the Honorable Attorney General, and then in big letters on the Sovereignty Protection Bill. But I treat them not as an amendment. However, I treat them as views of a stakeholder. Reasons or points of dissent. I have summarized at page 1 the reasons for my dissent. Insufficient consultation on the bill by government and the committee. The bill inverts the constitutional concept of sovereignty in favor of the state in contravention of Article 1. The bill is accompanied with an incurably defective certificate of financial implication. The bill infringes various principles and articles of the Constitution. The bill does not cure any mischief and is therefore misconceived. The bill is redundant as there exists sufficient legal framework to cure any mischief. At page 2, Right Honorable Speaker and colleagues, 3.1 on insufficient consultation by the government and the committee, I have stated what you're able to read, but with emphasis on Article 1. I also emphasize that the consultations were conducted here and we've never moved anywhere outside Parliament, as if the rest of Ugandans have no views to contribute on such an important subject. Sadly, influencing government policy is sought to be criminalized in this bill. See clause 7.4 of the bill. Right Honorable Speaker and colleagues, at page 4, I traverse the reasons that I have given, and I cite the case of Malema Bilis and others versus Attorney General, Constitutional Petition number 2 of 2018, and the decision of court to the effect, in summary, that consultation is not cosmetic, but goes to the root of our constitutional governance. In 3.2, that the bill inverts constitutional concept of sovereignty in favor of the state and contraventions of Article 1 of the Constitution, I associate with the elaborated submissions of my colleagues to avoid wasting time and eating much into my 2 minutes. 3.3, Madam Speaker and colleagues, the bill does not cure any mischief and is therefore misconceived. And the summary of this, one is that there exists sufficient legal framework. But if you look at page 6 of my submission, it is sought or to be understood that interference with the development and implementation of government policies and programs, which interference is funded by foreigners and agents, is the mischief. That foreign aid to civil society that comes along with conditions and parallel programs which conflict with government programs, this has given external donors, I understand, significant influence over the Uganda's political, social, and economic landscape, which has resulted into erosion of our values. See that the use of online platforms by foreigners and agents of foreigners to disseminate information facilitates social discord. The minority, and that is me now because it is a single man's minority report, note that the bill is misconceived since it is based on the wrong premise, that Uganda has no specific law upholding sovereignty of the country, which has resulted into continuous interference in the government's policies and programs by foreign countries and agents of foreigners. That no laws exist on the book to regulate activities of civil society, and that the law regulates the use of online platforms. I note that, 1, the Constitution only guarantees sovereignty of the people as against the state. No wonder the laws of Uganda are silent on this matter. There exist laws which include, among others, the NGO Act, the Money Laundering Act, and the Penal Code, which are sufficient to guarantee our security and sovereignty. In addition, I note that the bill further is misconceived because it restricts funds procured from abroad, thereby indirectly affecting the operations of financial institutions and the Bank of Uganda. Let me note that the majority report was uploaded yesterday at 4, so this one is taken care of. And for that matter, I will proceed to the next. It creates a regulatory arbitrage by extending the bill to persons and institutions already regulated by other acts of parliament. For emphasis, honorable colleagues, each and every sector we are talking about is regulated, including the political sector, which is so to be the target of this. And you are able to read for yourselves A up to K at page 9. Right, Honorable Speaker and colleagues, although the bill seeks to safeguard the sovereignty of Uganda from external influence, it grants agents of foreigners, once registered, the right to interfere with sovereignty. For instance, an agent of a foreigner who registers with the minister can implement government policy or government services under Clause 6, strangely, can influence development of policy under Clause 7, can implement government policy under Clause 8, can interfere with the electoral process under Clause 11, simply because of registration. All the activities that are allowed for an agent of a foreigner under the bill will affront Article 1 of the Constitution, whichever way you look at it, even when the minister allows. It is an affront. And the bill assumes that what is offensive to the Constitution becomes lawful simply by allowing it under an act of parliament, insofar as they will infringe the sovereignty of the citizens of Uganda by subjecting it to the influence of foreigners. The so-called acts allowed under the proposed law will still be offensive by their nature, being an affront to sovereignty. The minority note, therefore, that had the bill been conceptualized properly, Indeed, by being overly vague and ambiguous in relation to its application and the activities it seeks to regulate, it may be declared void for vagueness and the stretching beyond the parameters of the Constitution. At page 9, the bill infringes several articles. My colleagues have mentioned quite a number, specifically Article 1. I also opine that it offends Article 259 to the extent that it seeks to amend the Constitution by infection. This was canvassed in Paul Semogere Zakalo Luma and Juliet Reina Kafire versus Attorney General, Constitutional Appeal number 1 of 2002, in which the Supreme Court declared Section 5 of the Constitution Amendment Act 2000 as unconstitutional since it had the effect of amending Article 28, Article 41(1), and Article 44(c). Right Honorable Speaker, in that case, it was declared unconstitutional for having been passed without following the procedure under Chapter 8 of our Constitution. Court also discussed the effect of Section 5 of the Constitution Amendment Act, which proposed to introduce new clauses 2 and 3 of Article 97 with the intention of restricting citizens' unhampered access to information in the possession of the state. You may read for yourselves, and I'll proceed to page 12. The bill infringes on the following articles of the Constitution, making it grossly unconstitutional in form and effect. Number 1, unconstitutional deprivation of citizenship. Right Honorable Speaker, citizenship is not granted by statute. By seeking to reintroduce the foreign element against Ugandans, the bill offends Articles 9, 10, 11, 12, 13, 14, and 15 of the Constitution. Freedom of expression under attack. Article 29, 1A and B, which provide that every person shall have the right to freedom of speech and expression, freedom of thought, conscience and belief. Now, clauses 5, 7, 8, 9, 7, 8, 10, 12, and 13, and the definitions of disruptive activities in Clause 1 directly criminalize expression and association, including influencing the public to oppose the policy of government. Clause 2(2)(g), engaging or participating in a riot or unlawful demonstration or assembly. The definition of disruptive activities is offensive, and publishing information said to weaken the economic system. Clause 13. These restrictions are neither demonstrably justifiable in a free and democratic society as provided for under Article 43(2)(c), which provides that public interest shall not permit any limitation of the enjoyment of the right and freedoms prescribed under the Constitution beyond what is acceptable and demonstrably justifiable in a free and democratic society. 3. Freedom of association and assembly threatened. Right Honorable Speaker and colleagues, Article 38(2) of the Constitution guarantees every citizen's right to participate in peaceful activities to influence the policies through civic organization. Now listen to this. Clause 7(3), Clause 8(3), Clause 8(4), and 12 substantially burden and in some places extinguish that right by criminalizing conduct that constitutes its core exercise. 4. Right of equality invaded. Under Article 21(1), all persons are equal. Now, when it comes to the definition of foreigner, a Ugandan citizen residing outside, that has been sorted, and I accede to that. Then the foreigners in their own country and converts persons into those who deal with them. Intrusion of privacy, where the minister, the right to privacy of a person and property, and no person is subjected to unlawful search or unlawful entry into the premises. Clause 28 confers the person appointed by the minister to inspect the premises on an agent of a foreigner. Void for vagueness. I think the Honorable Betty Namboze has hinted on it, on the wide and arbitrary provision. Authorities to look at are Andrew Kalamaji versus Attorney General Constitutional Petition number 5 of 2016, which struck down Section 25 of the Computer Misuse Act, Charles Onyango and another versus Attorney General Constitutional Appeal number 2. The bill departs from the legality principle under Article 28. Interests of Uganda, I think Honorable Namboze has hinted on it, they are not defined. Agent of a foreigner, Clause 1. The definition is extraordinarily broad and captures any person who acts at the order, requests, under the direction, and control. I have specifically highlighted the threats that I consider legitimate in those bullet points at page 14. Now, the foreigner clause, I think, has also been canvassed together with disruptive activities and economic sabotage. At page 16, Right Honorable Speaker, I have highlighted the threat against the freedom from cruel, inhuman, and degrading treatment in the attendant authorities. The bill is accompanied with a defective certificate that has been canvassed by the Honorable Odul Jonathan, and I want to associate with him, but point out or be specific on the following areas. 1, that the estimates of revenue and expenditure over the period of not less than 2 years after the coming into effect of the bill, when passed, the impact of the bill on the economy are not canvassed in the certificate. The certificate simply laid down the principle of what we may achieve in broad terms without telling us what we are likely to spend on implementing and whether government is prepared to spend that money. To that extent, the certificate is incurably defective and cannot support this bill. The bill has also the potential to destabilize Uganda's balance of payments. I think reference has been made to the submissions of the Governor Bank of Uganda, and I associate in the same terms. The financial sector and de-risking the operational paralysis, the capital requirements and the funding gap, the policy framework inconsistency and the voluntary shocks have all been canvassed. And then the second last is the amendments proposed by the committee, good as they sound, are equally excessive and disregard the precedents of the House. They also disregard the procedure that ought to have been adopted as elaborated by my colleagues earlier. Finally, Right Honorable Speaker, for my reasons, this is where I'm going to refer to the letter written by my brother, the President. And here nobody will ask me whether he wrote it or not, because having said he's my brother, I think I know him better than anyone. The bill was rejected by the President and majority of the stakeholders in the committee that the committee engaged with. Right Honorable Speaker, the statistics have been given. Of all the persons that appeared, I think only 3 people supported, 3 stakeholders. The Honorable Yusuf Nsibambi, the Honorable Chiriowa Chiwanuka Attorney General, I treat him as a stakeholder because he was not the mover, and the gentleman from Fort Portal, Mr. Asimwe, that has been referred to. The President himself did state that this is not the bill that he initiated in Cabinet. But it does not stop there. Even General Severino Kahindo Tafire, who was stated to be the mover of the bill, evaded the committee proceedings, yet is the one who must have received the President's instructions, only to be misconstrued with immense respect by my son, General David Muhoze, who appeared, and not the minister.
Honorable David Moss is a son-in-law because he marries from him.
So yes, he's my son. In Africa, we don't say that. He's my son. So, Right Honorable Speaker, the general conclusion is that the minority, and that is me now, wish to remind colleagues that Uganda is here to stay, and therefore there is no need for firefighting. The country must not be stampeded into criminalizing politics, because politics seems to be left as the only target in the name and behind the curtain of sovereignty and security. The existing laws were not enacted in vain. They must be allowed to serve their purpose. The bill as proposed is inimical to democratic tenets, constitutional commands, and injurious to good conscience, which principles we must be jealously guarded and protected with utmost tenacity by all Ugandans of goodwill. The minority therefore recommend as follows. 1, the Protection of Sovereignty Bill 2026 that was read for the first time and referred to the Joint Committee on Wednesday, 15th April 2026, be rejected in its entirety for the reasons stated above. That the government undertakes to take practical steps to protect the sovereignty of the people from direct and indirect attacks, including by those claiming to fight for us. Medad Lubega Segona, MB Busiro East. I thank you.
Thank you, Honorable Medad, for that report. The opposition, yes, motion. There's a motion.
Right Honorable Speaker and Honorable colleagues, having heard from the substance of the majority report and the substance of the minority reports, I rise pursuant to Rule 17, Sub-Rule 1 of our Rules of Procedure, which states a member may, with the consent of the Speaker, move that a rule be suspended in its application to a particular motion before the House. I therefore move, Right Honorable Speaker, that the application of Rule 214, Sub-Rule 14, and 214, Sub-Rule 15, be suspended to waive the requirement of a 3-day period between the presentation of a report on the bill and the debate. I beg to move.
Seconded. Okwalinga, Namilyango, Echweru, Balamu, Odoi, Kabanda, Honorable Acheni, Silas, Charity, Nekesa, Rakajara, Lanyo, Abe, Akelo, General, Esther, Sanoni, Apoloto, Abeja, Ibanda, Omara, Chut, Water, Mariamu, Eric, Gabriel, Toroma, Amuria, Phyllis, Nyakato, my brother from Bugisu, Maxi, by the whole side, and 3/4 of the other side, the Vice President, the Prime Minister, the Government Chief Whip, Honorable Yusuf Sibambi, the Yellow Boy, and then Mama Wabana, Yellow Girl, and then the Honorable Businje, Honorable, all the elders, and all the disabilities. Honorable Nabakova is also there. Just 5.
Right Honorable Speaker, The justification of my motion are basically in threefold. One is that Rule 214 and Rule 215 are not falling under the confines of rules under Rule 17, Sub-Rule 4, that are entrenched, implying literally the two rules can be suspended. Reason number two is that this particular report on the bill was uploaded on our parliamentary information system. Members here present have perused through the report, and I believe with the turn-up you have in the House, we are ready to proceed just like we have proceeded with the main report and the minority reports. Reason number three is that the members who are required to discuss and debate this report as presented are here present and gathered in big numbers. Basing on the three reasons, I justify that my motion for suspension of the rule, if it pleases you, do carry the day. I beg to move, Right Honorable Speaker.
Thank you so much. Wilfred?
Right Honorable Speaker, I do strongly oppose the motion to suspend the rules on account of three grounds. One, it is apparently clear that the speed at which this bill has been moved, majority of the members are yet to access the records, the minutes of the committee meetings, and even the reports for them to internalize and appreciate the essence of this particular bill. Two,
how many members have reported to you that they have not had access to the information?
Right Honorable Speaker, speaking as the alternative Attorney General, we had 6 minority reports. Of course, you know the presentation has not been to its logical conclusion, and the majority of the people have remained seated here who did not stand up to support the motion, have not had time to look at the reports, read them, internalize, and even the minutes. Incidentally, even the minutes of the committee were not read by the mover of the motion.
They are there.
So, three, most importantly, Right Honorable Speaker, this particular bill touches fundamental rights of the people of Uganda, both within and without the territorial jurisdiction of this country. So it is important that the members be given time to debate the reports. Those who do not intend to debate can, yes, keep quiet, but give members opportunity to debate. So I do strongly oppose the motion to suspend the rules on debate of this particular important matter.
Attorney General.
Right Honorable Speaker, I think the question has been put more to the members because
I only want you to respond to what the shadow has said.
Yes, the honorable member seems to doubt the members' capacity to read quickly, which I strongly oppose, because I think these members have the capacity to read and understand these things. So it's not, of course, this law is not about Ugandans, it's about agents of foreigners. So I think, Right Honorable, the question should be put to the members to decide whether they are ready to deal with the issues in the bill or not. I beg to submit.
Honorable members, I put a question that Rule 2014, Sub-Rule 14 and 15 be suspended to enable the House to deliberate upon the report of the Committee of Protection of Sovereignty Bill without having to wait for the 3 days as per the rules. Those in favor say and the contrary nay. The ayes have it. The ayes have it.
Right, Honorable
members,
Speaker.
can you sit?
Honorable Speaker, the rules allow them to stand, and I wanted to quote for you the rule. Right, Honorable Speaker. Rule 107 of our rules of procedure provides for division. 1B. So a division may be ordered by the Speaker or Chairperson where B, the Speaker has announced the results of the voice voting, and immediately 40 or more members stand in their places, signifying their disapproval of the outcome of the vote. Honorable Speaker, from what we had, the noes had it. But you announced that the ayes have it. So these are more than 40 members who are standing up to say, put this to a division so that we count per head. It is the rules of procedure. Some of you don't read the rules. You need to start reading the rules. So, Madam Speaker, the rules allow for voting by division when 40 members stand up. These here are more than 40 members. So I would like to implore you that we do the casting by division so that we ascertain. Because as it stands now, we don't believe the announcement you made, Right Honorable Speaker.
Honorable members, I will not speak before you sit.
Madam Speaker, you have to kindly rule on the 40 members standing up.
Okay, you sit.
Right Honorable Speaker, the rule says you've got to first ascertain that these are 40 plus.
Honorable members, I don't need to ascertain. Even if you're 50, I am going to allow division. I am going to allow it. And then we see. And one thing I can tell you, whether we do what tactics of delay, we shall finish.
In brief chalinga agamba nti neoba nakola batya liino okuyita oba baagala oba tebaagala. In brief kyekyo Anita Among kyagezaako okubeera nga annyonnyola.
And then Honorable Bua appoint for ayes. The ayes can move this side and the nays move this side. Yes. Go to the lobby and yes. Ayes, but Majegere. And the ones abstaining can remain with me here.
Not us.
Honorable members, can everybody get out? Honorable Zaki. Go, 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 go. All of you go out. I'm the only one supposed to remain here. Eh? All of you go out. Honorable members, can you get out? Register yourselves from out. You've registered. I will call all of you back. I will call all of you back after you have registered. I want all members out. All members out. I will call you to come back. No, for you. It is only ex-official who can stay in. Ex-official. Rose, can I see you out? Rose? I don't want the process to be challenged. Yes. Honorable Baba, go to the laundry there. Betty. Honorable Namboze, first get out. We are going to call one by one. Honorable members from opposition, those who have registered, can pass through the rear door. The rear door is the other one, where I have one of my staff. Rear door. Read the name and the person enters. Where you see Aisha, that's where the rear door. And members of opposition enter. Enter through the rear door.
Now that you are going to start reading, read us one minute.
Members enter. Yes. Through the rear door. Yes, Fortunate, come. Government side, start coming from the rear door. Those who have registered. Eh? Yeah. Pass the other rear door. No, that door, that door. That is rear, that is your rear. Please enter. Honorable Amero, go back and sit where you sit. Honorable members, can we settle now? Honorable members, as we wait for the numbers in the VIP gallery this evening, we have Honorable Kahima Moses Mugabe from Ruhama East. Honorable Moses, welcome back. He used to be with us in the 10th Parliament. Karibuni sana. We also have Honorable Ilukoro Emmanuel from Bokora, Napak. Thank you. We have Honorable Achia Lokiru from GA County. Welcome. And then we have Honorable Etilu Margaret from Amoria. Most welcome and thank you for coming. Honorable members, can I receive my numbers from the clerks? Honorable members, the question was on suspension of Rule 214, Sub-Rule 14 and 15, and the Leader of Opposition raised an issue. He wanted to exercise his duty and his mandate by having a division and lobby. And I hereby announce the results. I want to congratulate opposition. You got 54 votes. $54 votes. And then NRM got 286. So the 286 against 54. The 286 have it. The ayes have it. So what I'd say that the ayes had it was correct. I had it very well. So the ayes had it. Thank you. Yes, Honorable Bua.
Madam Speaker, having ascertained the numbers in compliance with Rule 107 as raised by the Leader of Opposition, I beg to move under Rule 17.1 that in the consideration of the report on this bill, Rule 107 be suspended. I beg to move.
Aye.
Seconded? Aye. Yes. Seconded by the PM, by Honorable David, by Honorable Baka, Isibabi, by the whole 286. The ayes have it. Would you justify?
Right Honorable Speaker, my justification number one again is that Rule 107 is not entrenched, and as such, it can be suspended. Justification number two, it appears even when we have the numbers beyond their third required for passing a bill such as this, our good friends in the opposition would want to continue taking refuge under Rule 107 of the Rules of Procedure. And as such, I am justifying that that rule be suspended in the consideration of the report on this bill. You are taking refuge. You are not a refugee.
I put a question that Rule 107 be suspended to aid efficient consideration of the bill. Those in favor say and the contrary nay. The ayes have it.
Right, Honorable Speaker. Again, in consonance with Rule 107, 40 members are standing up because we believe it is the nays that
the rule has already been suspended.
No. Right, Honorable.
It has already been suspended.
Right, Honorable, if you could listen to me for a minute. Actually, we are challenging the result you have declared, Right, Honorable. So we should ascertain what you have declared, because you have declared that the ayes have it. We are saying no, the nays have it. So we still need to do a division to ascertain what you have declared. Right, Honorable, it's very simple because it's the rules. So we need to ascertain what you have declared according to Rule 107.
You go. We are
doing a division again.
Yes. We will not get tired of it.
Thank you for not getting tired, Right Honorable. Even us, we shall not get tired. I hope our colleagues this side are not tired.
Prime Minister. This is the last one and we shall have it.
Honorable members,
please,
Honorable Speaker,
please.
As a commander this side, I just want to use this microphone to tell my people that we shall not get tired. And it is going to be done today. Whatever play.
They told you to get out, not to come to the microphone.
So you go.
They told you to get out, not to come to the microphone and make noise. Prime.
Go. Go on your sides. All those, Gabriel, move this side. Gabriel, move your team this side. Amero, move your team. Honorable Ivan Remulicha, can you people move? Menya. Honorable Adoa, let's not, Honorable Lobo, let's not take time. Goretti, go away. Stop disturbing my age. Goretti, get out. Abeja. Honorable Pen, get out. Members who have registered, can we come back in? Members, can we settle? Honorable members, can we now settle down?
Microphone.
Honorable members, honorable members, can we have you in? Have you signed? You signed? Honorable members, can we settle down? The members who have signed, please enter. And don't squeeze yourself. Free sitting. Honorable Peace, there is a seat here. Solo. What is that? Where is the leader of opposition? No. I already have my book. Honorable members. Honorable members. Lop. Honorable members. The question is, honorable members, can I have order? The question is for suspension of Rule 107 that was moved by none other than Honorable Obua Hamson, the government chief whip. And those in favor are 292. And those against are 52. And abstainees is 1. The ayes have it. I have your books. The books have been delivered. Me, I have not been involved. Yes, Honorable Sibambi. Switch on.
Thank you for the opportunity.
Honorable members, can you listen to a senior counsel?
Right, Honorable Speaker. I move a motion that we move to committee stage. And I have only one reason. The bill has been discussed over and over. We have 7 reports before us, and we are ready to discuss clause by clause. So I pray that I move the House to go so that the question is put. 61. Yes, I beg to move that we go to committee stage.
Seconded. Seconded by Honorable Prosi, by the all front bench. Honorable Akol Menya, Honorable Mulimba, Honorable Vice President, Prime Minister, Government Chief Whip, Honorable Bahati, Honorable David, Honorable Baka, Honorable Yusuf, Honorable Mama Wabana, Honorable Amos, Honorable Abe, Honorable Gwang, Okasai, Elders, Dr. Cheng, Honorable Doug, Honorable Paul, Ibanda, Charity, Nekesa, Adoa, Rakajara, Olobo, Chemongesi, Werike, Panado, David, Muuma, Mulimba, Idi Sabirie, Apoloto, Sechindi, by the whole House on this side and the majority the other side. Honorable members, can I have some silence? I put a question that the Protection of Sovereignty Bill 2026 be read a second time. Those in favor say and the contrary nay. The ayes have it.
The Protection of Sovereignty Bill 2026, Bills Committee stage.
Honorable members, the quorum that we have on Zoom, we have 8 members, plus the ones we have in the House. That gives us 353 members. So we have the quorum.
Clause 1.
Clause 1 is interpretation. We could come back to the interpretation after.
Clause 2.
Madam Chair.
Right, Honorable Chair. That chair, not you. Right, Honorable Chair. I want to give some feedback. You know, I like to give you feedback. And I'm sure you will take it in good faith. This feedback is not for you, eh? It's for the chair. So you need to calm down. As I see there's a lot of excitement. I'm giving feedback to the chair. Not to you, yellow girl, or anyone else. So, right, Honorable, let me give you the feedback.
You know how we always... Honorable Lob, we know how we always get feedback. Me and you, we shall discuss. For now, for now, I am working for the whole House.
So allow me to raise my procedural matter right. Madam Chair, I was raising a procedural issue.
Madam Chair, the committee proposes...
Madam Chair, you allowed my procedural issue. Madam Chair, you allowed my point of procedure.
Can I look at clause 2 first, then I'll give you space.
Madam Chair,
it's about clause 2 also.
No, let him first.
Madam Chair, please listen to the point of procedure and then rule. It is you going to rule. The point of procedure is even about the clause he wants to embark on.
You wait, and he gives us his... Switch on.
Thank you, Madam Chair. That wasn't too hard. You see, Madam Chair, and this is the procedural matter that I want to raise. I have said here severally that the majority can have their way, but the minority must have their say. It's very important. Madam Chair, Rule 215, Sub-Rule 2. This is about dissent from decision of the majority. The member of the committee dissenting from a decision of the majority shall be given time to present the statement of reasons referred to. Honorable Chair, we were here battling literally for space. Honorable Dur hardly read his report. I think he had read a quarter way. A number of the others, you were saying 2 minutes. Madam Chair, this rule does not refer to two sides. It refers to a member of the committee with a dissenting opinion. There can be 10, there can be 20 dissenting opinions. Each of those members is accorded space in these rules. Madam Chair.
Yes.
And so I'm asking procedurally, Madam Chair. Are you saying that the views on our end, you do not want to entertain them? You don't think we add value because of the way the haggling has been happening?
Honorable members.
Our colleagues, you were saying they're going to upload the minority reports. But our colleagues, the other side, used 40 minutes to present their report, majority report.
Thank you.
Each minority report is meant to be accorded similar space. And that's all we are asking for. You people have got the numbers to do anything. You can even choose that tomorrow the sun will not rise because you have the numbers after all. So I don't know why you panic too much.
Honorable.
Our end has always just been asking,
Okay.
Madam Chair, accord us space, and that's what we have been
What is
asking
the
for.
procedure?
But it's been a fight. So my procedural question to you, Madam Chair, are you saying our views on our...
No,
Are you saying, Madam Chair, that the views on our end are irrelevant? They don't add any value? We want to know because of the way we are being treated.
Okay.
In the committee, you've heard the testimonies of our colleagues, Madam Chair.
Can I
They
respond?
told you they were not being... Let me finish in a minute, Madam Chair. You had our colleagues on the committee. Even in the committee, they were struggling to get space there. We thought that when we come here, our leader, who is the leader for all of us, you will be able to accord space to all of us. Because, Madam Chair, when you sit in that chair, you become a referee. You're not even supposed to descend into the arena to participate in debate. And we feel like you're not protecting us, Madam Chair, to air out our views. Are we irrelevant to you and to this House, Madam Chair? I would want to know.
Honorable members, Honorable members, Honorable Sanyonyi is a very good friend of mine. And Honorable Sanyonyi, I don't want and I don't love people who play double standards. When you came and told me thank you for giving my members time, as I asked, he thanked me. He thanked me for giving his members time. That's number one. Number two, I want you to listen to this. Number two, you know me, you don't whisper to me because I call a spade a spade. Number two, a member of the committee dissenting from the decision of the majority shall be given time. Time is not specified. I gave Honorable Nwagaba less than 5 minutes. He finished. He presented. Honorable Gilbert, he presented. No. I am the one speaking. I gave, Gilbert did not complain, everybody. And this time, we are past there. We are at committee stage. Can we go to committee stage? Two, you go to committee stage.
Thank you, Madam Chair. Madam
No.
Chair, the committee proposes to amend clause 2 of the bill as follows. The first amendment in sub-clause 1 by deleting the words any person who acts as. The second one by substituting for sub-clause 2 the following.
Procedure.
For avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platform.
I will give you after.
Engage in political activities in Uganda to further the interests of a foreigner.
I'll give you when it reaches
B.
that
Solicit,
clause.
collect, disperse, or dispense contributions, loans, money, or other things of value for the purpose of financing or sponsoring political activities to further the interests of a foreigner. C. Represent the interest of a foreigner before any agency or official of government of Uganda for the purpose
Madam
of
Chair.
engaging in political
Procedure.
activities in Uganda. D. Recruit, contract, engage, enter into a partnership or sponsor any person in Uganda to promote the interests of a foreigner for the purpose of engaging in political activities in Uganda. E. Agree,
Madam
consent, assume, or purport to act as, or who is or holds himself or herself out to promote the interest of a foreigner against the interests of Ugandans.
No, I have a procedural issue to raise.
F, without the approval of cabinet, influences the development of a policy of government or implements a policy of government. And G, influence the public to oppose the policy of government. Another amendment, Madam Chair, by inserting immediately after subclause 3 the following. For avoidance of doubt,
Madam
and
Chair,
notwithstanding the
right to
provisions
fair
of this
hearing
section,
is
this
non-derogable.
act shall not apply to monies or funding received from a foreigner by a supervised institution or a person or institution regulated by a regulatory body and an act of parliament for purposes of meeting its regulatory requirements or for purposes of undertaking its commercial, licensed or permitted activity under an act of parliament. B, a health or medical facility for purposes of performing an activity permitted under the laws of Uganda to be undertaken by a health or medical facility. C, an academic or research institution for purposes of funding research and innovation or any other education activity permitted under the laws of Uganda to be undertaken by an academic or research institution. D, a person for commercial, domestic, or family use. E, faith-based organizations for activities that are connected with the mission of the faith-based organization. Another amendment under clause 5, nothing in this, not clause 5, clause 2, paragraph 5, nothing in this act shall be construed as prohibiting or requiring compliance with this act for lawful foreign direct investment, portfolio investment, diaspora remittances, export proceeds, trade finance, commercial loans, humanitarian assistance, technical assistance, grants, concessional financing, development assistance, or any other lawful foreign exchange inflow or outflow and related activities. Justification, Madam Chair, to harmonize the provision with the scope of the bill as provided in clause 2, and to clarify the scope of the bill to avoid the possibility of extending the bill to any person and activity beyond the scope of the bill. I beg to move.
Honorable Minister.
Right Honorable Speaker and members, I concur.
Thank you very much, Madam Chair. Madam Chair, we didn't have opportunity, but first of all, I wanted to be on record that the committee have done great work compared to the original bill. Because, Madam Chair, I engage a lot on international issues and finance. If we had, you have opted to leave it out. If we had handled the interpretation clause, it would have made the remaining clause for us to move smoothly. But you have opted like that. It is now going to create for us, because interpretation means a lot. It's virtually 90%. Issues of foreign agent is what has disturbed us for all this time. So I wanted to request, Madam Chair, that after handling clause 2, we go back to clause 1, handle interpretation, because it sorts out the bill entirely and really closes the matter.
I agree with you.
Thank you.
I put a question that clause 2 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 1.
Clause 1.
Madam Chair, the committee proposes to amend clause 1 as follows. The first one is by substituting for the definition of agent of a foreigner the following. Agent of a foreigner means a person who engages in any of the activities referred to in section 2 as an agent, representative, or employee of a foreigner on the order, request, supervision, or under the direction or control of a foreigner, or while being financed or subsidized by a foreigner. Another amendment in the definition of disruptive activities by deleting paragraph C. Another one.
E.
Oh, sorry, paragraph E. Another one is by substituting for the definition of foreigner the following. Foreigner includes a non-Ugandan citizen who engages, undertakes, supervises, controls, finances, or subsidizes the activities specified in section 2.2. B, a foreign government, consulate, high commission, embassy, or other diplomatic mission which engages, undertakes, supervises, controls, finances, or subsidizes the activities specified in section 2.2. And C, a corporation, non-government organization, or any legal entity, incorporated, unincorporated, or registered outside Uganda, which engages, undertakes, supervises, controls, finances, or subsidizes the activities specified in section 2.2. D, an international or multinational organization which engages, undertakes, supervises, controls, finances, or subsidizes the activities specified in section 2.2. Another amendment by deleting the definition of person. Another one by inserting the following definitions in their appropriate alphabetical order. F, activities means any activity aimed at influencing the enactment of legislation, the formulation of policy, or the decision making of government or the people of Uganda, and includes A, fundraising, sponsoring, registering, nominating, supporting, or campaigning for a candidate in an election. B, registering, funding, and campaigning for a political party in an election. C, fundraising, campaigning, canvassing for support, supporting or opposing a political party or a candidate in an election. D, any activities aimed at influencing the outcome of an election. E, any activities aimed at influencing the will and the consent of the people of Uganda to determine who shall govern them and how they should be governed. F, any activities aimed at influencing, imposing, or normalizing ideologies which are inconsistent with the Constitution or which conflict with any culture, customs, or norms of any of the communities listed in the third schedule of the Constitution. Another definition is interest of a foreigner, means interest of a foreigner that are aligned with the principles. I will come again. Interest of a foreigner means interest of a foreigner that are not aligned with the principles and laws adopted by Uganda. Another, I will come again. Interest of a foreigner means interests of a foreigner that are not aligned with the principles and laws adopted by government. Interests of Uganda means the national interests of Uganda based on the principles of national interest and common good enshrined in the national objectives and directive principles of state policy as provided for in the Constitution, laws of Uganda, and government policy. Foreign policy means a policy developed by a foreigner. Government policy means a statement, decision, or actions of government on how a sector is regulated or governed, issued in accordance with the Constitution and laws of Uganda. Interest of Ugandans means the interests of Uganda. Justification: to limit the application of the bill to only agents of foreigners and not any other person. Second, the amendments are intended to harmonize the definitions with the scope of the bill as provided in Clause 2. The other one is under the definition of foreigner to exclude the application of the bill to Ugandan citizens residing outside Uganda. To remove the power of the minister to declare any person a foreigner under the definition of a foreigner. And under the definition of the phrase disruptive activities, to remove the restriction on the recruitment and employment of persons, which was broad. And finally, to define words and phrases which are used in the bill in order to enhance clarity. I beg to move, Madam Chair.
Thank you. Honorable Baka, where would you place the honorary councils? Like the Kirumiras, like the Wawamunos, who represent other countries in our country?
They are diplomatic missions, Madam Chair.
If they are diplomatic missions, then you're going to consider them foreigners.
Right Honorable Chair, naturally a diplomatic mission has an interest of a foreign state. That's their interest here. So if I take up that job as a diplomat, as an honorary counsel here, I'm here to represent the interests of the other countries. So they'll be covered by that. But only if they do the activities in 2-2. Only if they do the activities in 2-2. In clause 2-2.
Yes.
Thank you. Thank you. We, in the definition, we have talked of foreign policy to refer to the policy of foreigners. Are we sure in the whole law we don't mention foreign policy of Uganda? Because there is, I believe there is where we say we are protecting also our interests like foreign policy. So now if we limit foreign policy to mean policies of the outside, what about our foreign policy? Chair, the second one, it answers together.
Well, that one is qualified later on in the bill. It's clearly stated foreign policy of Uganda. Everywhere else where you have foreign policy, it means a foreign government. But foreign policy of Uganda is clearly set out.
Thank you, Chair. Can the Attorney General also help me in the cases of situation where you have dual citizenship? In the cases of dual citizenship, because I know there are Ugandans who have acquired dual citizenship, how do we handle them regarding this issue of foreigner? Because I know even in this house.
Even those are citizens of
Yes.
Uganda, so they're excluded.
Yes.
Thank you very much, Madam Chair. Madam Chair, the issue of having political parties, because this clause basically, the purpose of this bill is to deny political parties and civil society to receive resources that are not declared. We have the NRM that have been receiving funding from partner parties like from China. Now with this, they are putting a rope on their neck. That is true. So I'm just telling you, are putting a rope on your neck.
Honorable, if I had it well, all those with the acts of parliament, we have the Political Parties Act. All those are entitled, including FDC. So you're not excluded. You can receive your money from wherever because you have an act of parliament that supports you.
Chair.
Huh? Yes?
Right Honorable Speaker and members, I want to agree with the chairperson, except I want to refer members to interest of a foreigner and edit out principles and replace them with policies and laws adopted by government. Policies, not principles.
Thank you. Madam Chair, as you consult, I would like the Attorney General to clarify on this. Thank you, Madam Chair.
Honorable Minister was making an amendment. Can you rephrase the amendment you're making?
I said we were on clause 2.
On the definition.
And I referred honorable members to interest of a foreigner to mean interests of a foreigner that are not aligned with the policies and laws adopted by government, not principles.
Okay. AG?
We agree with the principle that has been set out in the amendment. I think the issue is that government has policies, not principles, has policies. So we want to amend that to read policies and laws developed and adopted by government of Uganda.
Thank you. I put a question that clause 1 be amended as proposed by the committee and further amended by the AG. Those in favor say, and the contrary nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 3.
Clause 3.
Madam Chair, the committee proposes to amend Clause 3 as follows. Clause 3 of the bill is amended by inserting immediately before the word ministry, appearing in the third line, the word relevant. Justification: to require the department to consult the relevant ministry while implementing the act. I beg to move.
Chair. Minister.
No objection.
Yes.
You see, there's a bill we passed recently to make it vague, because you see, this bill is about financial flows. Now, when you say relevant ministry, why don't we say minister responsible for finance, so that it is very clear? Because when you leave it vague like this, we will have a challenge.
AG.
Right, Honorable Chair, this bill is not about financial flows. This bill is about influencing policy making in Uganda. So every different ministry has its own policy that it is entitled to handle. So it's not about money. This bill is not about money. It's about influencing policy making decision in Uganda.
I put a question that clause 3 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 3 as amended.
I put a question that clause 3 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 4.
Clause 4.
Madam Chair, the committee proposes to amend Clause 4 as follows. Clause 4 of the bill is amended in subclause 1 in paragraph D by inserting the words "or foreign nationals," and in paragraph H by inserting the word "perform" immediately before the word "any." Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2. I beg to move.
Honorable Minister.
No objection.
AG.
No objection.
I put a question that clause 4 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 4 as amended.
I put a question that clause 4 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 5.
Clause 5, Chair.
Madam Chair, the committee proposes to amend Clause 5 as follows. Clause 5 of the bill is amended in subclauses 3 by substituting for the words "a person" the words "an agent of a foreigner." By substituting for subclause 4 the following: an agent of a foreigner who intentionally promotes the interests of a foreigner against the interests of Uganda commits an offense and is liable on conviction to, in the case of a legal entity, to a fine not exceeding 100,000 currency points, and in case of an individual, to a fine not exceeding 50,000 currency points or to imprisonment for a term not exceeding 10 years or both. Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2, to make the penalty and fine proportionate to the offense, and finally to provide for criminal intent in the commission of the offense. I beg to move, Madam Chair.
Right, Honorable Speaker and members, our original provisions were for deterrence, knowing that we have the safeguard of court discretion. They were just maximum, but middle ground is okay. We can have the amendments as done by the committee.
The person who what?
Who intentionally promotes.
Who intentionally promotes. How do you gauge intention? The burden of proof.
The burden of proof always lays on the state, which alleges. He who alleges must prove. So the state must prove that was done intentionally.
You okay with the wording?
Yes.
Yes.
I would request that we rephrase the interest of a foreigner, because if, for example, we promote the interest of Kenya that wants a road to pass the standard gauge railway, for example, to pass Tororo and head to the north, and the government wants the standard gauge to come to Kampala. Me coming from the east, I want it to go to the north to promote trade. And if it is being promoted by the government of Kenya, I will support that idea. And I might be criminalized.
Honorable Eki, you're reading this in isolation. It is saying of a foreigner against the interest of Uganda. SGR is not against the interest of Uganda. It is in favor of Uganda. Don't read in piecemeals.
Reading in piecemeal. In that case, the interest of Uganda will be SGR to come to Kampala. Kenya's interest is to come to the to go to the north.
I put a question that clause 5 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 6.
Chair.
Madam Chair, the committee proposes to amend clause 6 as follows. Clause 6 of the bill is amended in subclause 2 by deleting the words a person. In subclause 3 by deleting the words any person or. By substituting for subclause 4 the following. An agent of a foreigner who intentionally performs the functions or offers services for which the government is responsible for without the approval of the relevant government agency commits an offense and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in the case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years or both. In subclause 5, by substituting for the word a person, the words an agent of a foreigner. Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2, and to make intention an element of the offense, and to make the penalty proportionate to the offense. I beg to move.
Minister.
I concur, Right Honourable Speaker.
AG.
No objection, Right Honourable Speaker.
I put a question that clause 6 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 6 as amended.
I put a question that clause 6 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 7.
Chair.
Clause 7, Madam Chair, is proposed to be amended as follows. Clause 7 of the bill is amended in subclause 3 by deleting the words a person or. By substituting for subclause 4 the following. An agent of a foreigner who knowingly develops a policy without the approval of cabinet commits an offense and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years or both. In subclause 5, by deleting the words and implementing. Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2, to provide for criminal intent in the commission of the offense, to make the penalty proportionate to the offense, to harmonize clause 7, paragraph 5 relating to development of government policy, and clause 8, paragraph 8 relating to implementation of government policy. I beg to move.
Minister.
I want to draw the attention of members to subclause 4. An agent of a foreigner who knowingly develops, I want to add, and implements a policy without the approval of cabinet commits an offense and is liable on conviction, blah, blah, blah. So I want that we amend by adding and implement.
Implements.
I concur with the amendment given by the minister.
Have you looked at 5 from the committee's recommended from the report, where they say the minister may by regulation prescribe the procedure and the requirements for formulating and implementing the policy of government. So you're deleting that. By implementing.
We are adding to 4, where they say knowingly develops. An agent of a foreigner who knowingly develops. To develop, you may develop it and keep it in your mind. But we want to add and implements. So if you develop it in your mind and attempt to implement it here, that's when you commit an offense. So in 5, we are saying that if you want to implement a policy that you've come up with, you have a policy. You go and you tell government what policy you have, and they will tell you how to implement it in Uganda.
Yes. Yes,
Madam Chair.
Christine.
Chair.
Christine.
Chair, I am of the view that knowingly developing a policy and implementing it, what will happen to institutions like Red Cross that come in disasters and they don't need that other approvals? So we could do qualify it other than
Red Cross is not an agent of foreigners. They are funded by government.
It is a legal entity that sometimes represents foreigners. Yes.
No.
Yes.
Not unlawfully.
Madam Chair,
Yes.
I want making a proposal that we amend and replace a word without approval of cabinet and say without approval of government, because sometimes we debate here and the courts and the other government agencies. So when we restrict and tie ourselves only to cabinet, we are surrendering too much power and making cabinet to be. So I'm proposing that instead of cabinet, we say without approval of government. That is better definition. Government is broad. It has nothing. And include cabinet.
Cabinet is vague.
Government is not the policy making
Christian,
organ. It's cabinet by constitution.
The Red Cross
by constitution,
is a creation.
cabinet.
Red Cross is a creation of the Geneva Convention, and we are bound to abide by it. So it is not a foreign. Yes, AG. Yes.
Thank you very much, Madam Chair. Madam Chair, a policy is a plan. It can be some frameworks, and some of these institutions may come up with these frameworks and run to implement them, especially in the local governments, without government approval. So I don't see any problem. Yes, I don't see any problem with maintaining what the committee has presented with the amendment of a foreigner developing and implementing a policy without the approval of cabinet. Government is too broad. Let's leave it as cabinet, because it's cabinet's responsibility to actually approve policies in this government. So let's leave it with the cabinet. The policy must be approved by cabinet.
Madam Chair, you had picked me. You had picked me, Madam Chair.
Honourable members, policy formulation is an executive role. So by the time it is put there that cabinet should do it, because when you put government, even us then, Parliament will also do the same, local government, even so The amendment. Just a minute.
Right, Honorable Chair.
Just a minute.
The committee proposed to amend clause 7.4 to read an agent of a foreigner who knowingly develops a policy. We are proposing that we are saying an agent of a foreigner who knowingly develops and implements a policy. And we are proposing that in subclause 5, the minister may, they're proposing to delete and implementing, we are proposing that and implementing remains. That's the amendment.
That's what I said.
Yes.
That's what I said. That is 5. That is what? That is what? 7.
Clarification.
Can you give information?
I'm here as Lop. I'm here as Lop. Lop has appointed me.
Honourable members, I put a question that clause 7 be amended as proposed by the committee and further amended by the Attorney General. Those in favour say and the contrary nay. The ayes have it.
Clause 7 as amended.
I put a question that clause 7 as amended stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 8.
Clause 8.
Madam Chair, clause 8 is amended. It is proposed by the committee to amend as follows. By deleting subclause 1 and in subclause 3 by deleting the words a person or by deleting the word implement. In subclause 4 by deleting the words a person or the person or wherever the words appear in the provision. By deleting subclause 5. In subclause 6 by deleting the words a person or. By substituting for the words the person or agent the words an agent of a foreigner. And in subclause 7 by substituting for the words a person the words an agent of a foreigner. Justification to restrict the bill to only agents of foreigners as prescribed in clause 2. Subclause 5 is deleted in order to remove unnecessary bureaucracy in implementation of policy and to harmonize clause 3 and 4 of the provision. I beg to move.
Honorable AG, after reinstating implementation, this becomes subsequential. So we cannot delete it. Yes.
Right, Honorable Chair and members, if it is a policy of government that has been adopted by government, anyone can implement that policy in Uganda, so long as it is government policy. So if you write here, an agent of a foreigner shall not implement government policy, then that will be contradictory. Anyone can implement government policy, but it must be a policy of government. We have friends of ours who are in a humanitarian community. They come to assist us build schools, build boreholes. That is okay because it's government policy. But you cannot implement a policy which is not government policy. So I agree with the committee on their proposed amendment.
You agree with the committee on the deletion of implementation?
Chair, what happens where the government does not have a policy?
Again, Right Honorable Chair, that has been provided for as well. If government does not have a policy on a particular matter and a member feels, if government does not have a policy on that matter, then you should take that bright idea to cabinet to adopt the policy and then implement it.
Honourable members, I put a question that clause 8 be amended as proposed. Those in favour say and the contrary nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favour say and the contrary nay. The ayes have it.
Clause 9.
Foreign policy.
Madam Chair, the committee proposes to amend clause 9 as follows. Clause 9 of the bill is amended by, in the head note, by inserting immediately after the word policy, the words of Uganda. In subclause 4, by deleting the words a person or. Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2, and to provide clarity on the head note.
Minister.
I agree, Chair, because we need to distinguish between Uganda's policy and the foreign policy of other countries.
No objection.
I put a question that clause 9 be amended as proposed. Those in favour say on the contrary nay. The ayes have it.
Clause 9 as amended.
I put a question that clause 9 as amended stands part of the bill. Those in favour say on the contrary nay. The ayes have it.
Clause 10.
10.
Madam Chair, the committee proposes to amend clause 10 as follows. In the head note, by deleting the words of another country. In subclause 1, by substituting for the words a person the words an agent of a foreigner. By substituting for subclause 2 the following: an agent of a foreigner who engages in any activity, solicits, receives, or obtains any assistance from a foreigner to sponsor or organize a meeting or any function with the aim of promoting foreign policy in Uganda that has not been adopted by cabinet as government policy, commits an offense and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in the case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years, or both. By inserting immediately after subclause 2 the following: the minister may, in consultation with the cabinet, by regulations, prescribe the procedure for adopting foreign policy. Justification: to restrict the bill to only agents of foreigners as prescribed in clause 2. To empower the minister to prescribe the procedure for adopting in Uganda the foreign policy of another country, and to make the penalty proportionate to the offense. I beg to move, Madam Chair.
Minister.
No objection, Chair.
AG.
No objection, Right Honorable Chair.
I put a question that clause 10 be amended as proposed. Those in favour say on the contrary nay. The ayes have it.
Clause 10 as amended.
I put a question that clause 10 as amended stands part of the bill. Those in favour say on the contrary nay. The ayes have it.
Clause 11.
Clause 11.
Madam Chair, the committee proposes to amend clause 11 as follows. Clause 11 is amended by substituting for subclause 3 the following: an agent of a foreigner who intentionally influences the will and consent of any person to decide on how he or she shall be governed contrary to subsection 1 commits an offense and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in the case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years, or both. In subclause 4, by substituting for the words a person the words an agent of a foreigner. Justification to restrict the bill to only agents of foreigners as prescribed in clause 2, and to make the penalty and fine proportionate to the offense. I beg to move, Madam Chair.
Minister.
No objection, Chair.
AG.
No objection.
Clarification. Clarification, Chair.
I put a question that clause 11 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 12.
Clause 12.
Madam Chair, clause 12 is proposed to be amended as follows. Clause 12 of the bill is amended in subclauses 1 by deleting the words a person or, by substituting for subclause 2 the following. An agent of a foreigner who engages in any activity or solicits, receives or obtains any assistance from a foreigner to sponsor, organize a meeting, or any function with the aim of interfering with the operations of government, commits an offense, and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in the case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years, or both. By inserting immediately after subclause 2 the following. For purposes of this section, an agent of a foreigner interferes with operations of government if the agent of a foreigner intentionally obstructs, impairs, hinders, or prevents a public officer or any other person occupying a public office from performing his or her functions. Justification to restrict the bill to only agents of foreigners as prescribed in clause 2, to define what amounts to interfering with the operations of government in order to comply with the legality principle enumerated under Article 28, Clause 12 of the Constitution, to make the penalty and fine proportionate to the offense. I beg to move, Madam Chair.
Minister.
No objection.
Okwalinga.
Have no objection.
Okwalinga.
Thank you so much, Madam Chair. Madam Chair, the clarification I wanted to seek from our land Attorney General relates to the matter that concerns the sanctions that we give to, that we have mentioned in the law to somebody who has attempted to influence our policy, especially when it comes to an embassy. Because whereas a legal entity, we can follow up the directors. If it is a foreign individual, we can follow the individual. What about if it's an embassy, a government, a foreign government? Whom do we sanction when it's the foreign government who has actually sponsored or influenced our foreign policy? Do we put sanctions and dismiss them from Uganda? We need to clarify on that. Thank you.
Additional information. Madam Chair, on top of that one, in this very house, it is on record that the persons who attempted either to promote either their foreign policies, I wanted to know, because like homosexuality in this very house, they are citizens of this country. Okay, wait. Okay, maybe let me leave that one. Okay, I could leave that one. Let me have others. Madam Chair. Secondly, there are
Honorable.
Okay, I will withdraw that one. I withdraw.
Honorable, I said we needed a legitimate debate at a time of homosexuality. Honorable Fox Odo is married to 2 beautiful women. He's not a homosexual.
Okay.
He does not promote. And
He's not a foreign agent. He's not a foreign agent.
and he's withdraw.
Madam Chair,
Not in this house.
I beg to withdraw that one on the basis that he's married to 2 women. But Madam Chair, the last one,
Madam Chair,
this one is a bit very complicated because there are many churches in this country, many churches coming up in Uganda. Some of them in particular tell people not to go for formal treatment. Some of them instruct citizens not to go to hospital to get formal medication. People eventually stay and die in churches. And just a moment, I'm just thinking because you don't know whether the Bible is foreign. We want to be sure whether the Bible, my land colleague Attorney General.
There is one called Kibwetere, you remember?
Yes, they block Uganda.
You mentioned the name.
They block Uganda through faith from going to seek medication.
You mentioned the name Kibwetere.
Like Kibwetere. They are blocking citizens of this country. My land Attorney General, my dear land colleague, my dear land Attorney General, I want you to know, are these foreign interests? Where does the Bible belong? So that we know whether they are agents of foreigners. I beg.
Yes,
Madam
Moses.
Chair.
Moses.
Madam Chair, maybe Attorney General will clarify this too.
Moses.
Yeah, thank you, Madam Chair. I just wanted to seek indulgence of the Attorney General. Instead of saying intentions, say knowingly influence. We use the word knowingly.
You knowingly that?
Yes, thank you.
And that is what
Chair.
I said at the beginning.
Chair, I needed some clarity from the Attorney General on this.
Yes, it is close 12. Instead of saying intention or intended, you say unknowingly influenced. They are not the same, but can they be used interchangeably? That's what I'm seeking.
Eji, what is your comment on this?
Chair, Eji could respond at once.
Do we move by what?
Yes, we can use the knowingly. I agree. I have no objection to that.
Whatever intention.
Yeah, you can say knowingly or intentionally.
Yes.
Chair.
Knowingly. Knowingly, wherever intentionally appears.
Yes, I agree.
Yes.
Attorney General needs to clarify this. I'm a little bit lost on what amounts to disrupting government operations. For example, our policy is that citizens must be treated here. But we have a number of well-to-do government officials who choose to go for medication out of the country. It means they will be promoting the foreign interests of that country. So
honorable members,
so
I put a question. I put a question that clause 12 be amended as proposed and knowingly replaces intentionally wherever it appears. Those in the favor say and the contrary nay. The ayes have it.
Clause 12 as amended.
I put a question that clause 12 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 13.
Prohibition of economic sabotage.
Madam Chair, the committee proposes to amend clause 13 as follows. Clause 13 is substituted with the following. Prohibition of economic sabotage is the head note. An agent of a foreigner who knowingly publishes false information or participates in any disruptive act or activity that weakens, undermines, or damages the economic system or viability of the country to cause economic disruption, insecurity, or instability commits an offense of economic sabotage and is liable on conviction in the case of a legal entity to a fine not exceeding 100,000 currency points, and in the case of an individual to a fine not exceeding 50,000 currency points, or to imprisonment for a term not exceeding 10 years, or both. Justification: to restrict the bill to only agents of foreigners as prescribed in Clause 2, to provide for criminal intent in the commission of the offense, and to make the penalty proportionate to the offense. I beg to move, Madam Chair.
Minister.
No objection.
AG.
No objection.
Kanya, I'm tired. I put a question that clause 13 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 13 as amended.
I put a question that clause 13 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 14.
Clause 14. I put a question that clause 14 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 16.
Clause 16.
Madam Chair, we propose to amend Clause 16 as follows. Clause 16 of the bill is amended in subclause 1 by deleting all the words appearing